Так,
Guten Morgen, Lars.
доброго ранку, шановні учасники. Я
Good
попрошу
morning, dear
наших
participants.
гостей,
I will ask
які
our
завершують
guests
приємне спілкування за
who are
гарячою
finishing their
кавою.
pleasant
Я
conversations
запрошую
over
вас
a
долучитись
cup of
до нас
coffee,
для того, щоб
asking you to
спокійно
join us here in this
долучитися.
room, to take your
І
places.
ми скоро починаємо.
We will
50
be
хвилин
starting
мені.
soon, in a
Тому
minute or
що з
two,
нами в онлайн-режимі
because we have
багато
our
експертів
international experts with
чекають
us
на
online who are
початок.
waiting for the
Ми
beginning.
вчасно розпочнемо, вчасно
We will
завершимо.
start on time, we will
Повага
finish on
до
time.
один до
After
одного.
all, that's
Тому
respect to one
запрошую всіх
another.
до зали, будь
So I'm
ласка.
asking all of you
Дякую.
to please come into the room. Thank you.
Доброго ранку ще раз усім.
Good morning once again, everybody. I'm very happy to see so many people who care about administrative justice, who are creating justice today. And I'm very happy that once again, for the fifth time now, we're meeting at our international practical workshops, seminars, and I'm very happy to see here judges of the first instance of courts of appeal. We also have with us our long-term friends, international experts that I will introduce a little later. You already could see their names in the agenda. Here in this room, we also have, for the first time, students at this meeting. These are winners of a competition that we will also tell you a little bit more about later during the awarding ceremony. For me, it's a great honor today, for the fifth time, to start our international practical workshop, where we're going to discuss the determining of the constitutionality of a law or another legal act, whose competence is it under Article 7 of the Code of Administrative Procedure of Ukraine. I'm giving the floor now to Mikhailo Smakovich, our leader of administrative justice. Good morning, dear friends. Good morning, dear experts. Good morning, participants of this practical workshop. Dear friends, dear colleagues, it is already a tradition to have such an important workshop at the Supreme Court of Ukraine. We started doing that in 2019, and all this time at these workshops we have been discussing the issue of the use of the Constitution by administrative courts. In the current situation where the legal relations are being transformed and the role of the judiciary is increasing as regards establishment of the rule of law, rule of the Constitution, administrative courts play one of the central roles within the system of protection of constitutional rights and freedoms against violations by the authorities. This year is important for the administrative justice in Ukraine. 20 years ago, on the 6th of July, the Code of Administrative Justice was adopted in 1995, 20 years as of the 1st of September 2005, since the administrative justice was established and launched in Ukraine. And during those decades, the Code of Administrative Justice was established as a fundamental basis for the rule of law, as a guarantee of transparency and accountability of the authorities, as well as an effective tool for protection of constitutional rights and freedoms and their legal relations in the country. And during all those years, it is the administrative justice that has been facing the need to assess whether the authorities work in compliance with the main law of Ukraine, which requires that the judges who have a high level of constitutional culture and a deep understanding of the principle of the direct action of the Constitution of Ukraine. The problem of determining the constitutionality of laws or other legal acts is directly related to the main principle of the rule of law, the Constitution of Ukraine. Within the system of public law, it is the constitutionality that is the criteria for the correctness of the actions of the authorities. And let me emphasize that Article 7 of the Code of Administrative Justice is important to ensure the rule of law and administrative justice, because it determines what the court can do in terms of the use of the legal acts that are counter to the Constitution. And during this workshop, we will focus on several key issues that are important, both theoretical and practical, for the administrative courts. First of all, we will be speaking about establishing by the administrative justice courts of conflicts between a law or another legal act to the Constitution of Ukraine, even to understand the jurisdiction of the administrative courts and the Constitutional Court of Ukraine. Second, we will discuss the issue of identification of risks of legal effects when administrative court makes a decision, when it decides unconstitutionality of a legal act by itself. Third, we will analyze the procedural aspects of suspending a case until the issue of constitutionality of a law or another legal act is decided by the Constitutional Oversight Authority. We will also focus, as we have seen such problems now, on the mechanism of applications by the local administrative courts to the plenary session of the Supreme Court as regards petitions to the Constitutional Court if there are doubts about constitutionality of a legal act. We will also focus on looking for effective solutions in the cases that are heard during the martial law in Ukraine in terms of constitutionality of restrictions of the rights and freedoms. These issues would allow us to discuss the framework of judicial competence to ensure proper rights in the cooperation between the administrative courts and the Constitutional Court, the peculiarities of how administrative courts can use the Constitution of Ukraine while hearing public conflicts, the issue of competence or joint work while we're hearing cases, and the legal effects of improvement of the legal justice as a guarantor of the interests of human beings in public legal relations, and the role of administrative courts in ensuring the principle of the rule of law and the rule of the Constitution in the current situation. This discussion is not only of practical importance for the judiciary, for the judges of other jurisdictions, but it has important significance in terms of doctrine, because it's about the correlation of powers among those judges and developing proper culture of the use of the unique principles in justice administration. The administrative vector of justice is one of the key priorities for establishing Ukraine as a state of law, and it's important for the judicial practice to study the experience of European countries, in particular as regards determining constitutionality of laws and other legal acts by other countries. The establishment of European standards in our case law will promote improvement of democratic foundations of the work of the government, providing the rule of law and implementation of Ukraine's strategic course toward European integration. I'm confident that our today's event, today's professional dialogue, and today's considerations that we will hear with participation of highly qualified experts would help us improve cooperation between representatives of the legal community, judges of different instances, academia, and increase the level of arguments, qualitative arguments of the judges, and establishing administrative justice as a guarantor of the Constitution of Ukraine and public legal relations. I wish to all the participants of this seminar very professional discussions, practical important results that will become the basis for the further development of the national case law and in its constitutional legal dimension. I'm extremely grateful to the armed forces of Ukraine, the defenders of my country, that every day are defending our security, our independence, our territorial integrity, and the state sovereignty, as well as identity of the Ukrainian nation, Ukrainian culture, and the Ukrainian people, as they're defending the European democratic values. Dear colleagues, I wish you all peaceful sky, a victorious sky, resilience, inspiration in implementing new constructive ideas, and the fruitful work to establish, to ensure the rule of law and the rule of constitution, and of course, victory to our independent European state. I also want to thank all of our co-organizers who are helping us in this effort. I want to thank the project manager for Ukraine and Vietnam, the German Foundation for International Legal Cooperation, Angela Schmeich. I'm grateful to Virgilas Valančius, the senior international expert of the support to the integration process in the justice sector component lead, Bravo Justice. I want to thank Mykola Hnatovsky, judge of the European Court of Human Rights, who has visited us. I also want to thank Mykola, the Doctor of Law, ex-judge of the Constitutional Court of Ukraine. I want to thank Alexander, who has come here to us today, and everybody who's with us here today. Thank you, because everything we are doing, we're doing it so that Ukrainian justice and administrative justice and general the judicial system is in line with international standards. And everyone who would come to Ukraine should be able to have judicial protection on the level that is in line with European and international standards. Thank you very much and have very fruitful work today. And thank you for being here today. And I bow to all of you because you keep working, because you keep performing the sacred duty of the judiciary, even during the martial law and in the wartime. You provide the right to judicial protection to everyone who needs it in Ukraine. Slava Ukraini.
Дякую, Михайло Іванович.
Thank you, Mr. Smokovich. And I'm very happy to give the floor to Angela Schmeich, Project Manager for Ukraine and Vietnam of the German Foundation for International Legal Cooperation, please.
Ja, vielen Dank. Einen schönen guten Morgen. Sehr geehrter, lieber Herr Präsident Smokovich, sehr geehrte Frau Bilak, Richterin des Verwaltungsgerichts, sehr geehrter Herr
Thank you very much. I'm very dear Mr. Smokovich, dear Ms. Bilak, dear Judge of the Cassation Administrative Court, dear ladies and gentlemen. On behalf of the German Foundation for International Legal Cooperation here at SET, I want to greet you all at this conference that you regularly invite us as well. We, as the German Foundation for International Legal Cooperation, are very happy that we follow you and accompany you in the further development of administrative justice for several years now. Today, we're celebrating the 20th anniversary of the Code of Administrative Justice in Ukraine.
Die Durchdringung des Verwaltungsrechts durch das Verfassungsrecht und immer mehr auch die
and the fact that both laws are related, the administrative law and the constitutional law, and also the influence of the European law, the national law. Let me give you one example of our cooperation. The latest one is the working visit last week that we had together with KISET. The judges of the Constitutional Court of Ukraine and the Supreme Court of Ukraine met in Germany, their colleagues from the Federal Supreme Court, and the Federal Financial Court, and the Federal Court of Patents, as well as their colleagues in Austria. They met the judicial system of Germany, Austrian system, and could compare it with the Ukrainian judicial system. Our cooperation with the Ukrainian partner is alive thanks to such active experts and specialists from Germany. One of such important actors in our cooperation, who has been working for 20 years now together with us, is Professor Brocker, who is the head of the president of the Constitutional Court of Administrative Court of Rhineland-Palatinate and Rheinland-Pfalz. And last year, in 2024, he received the name of Doctor Emeritus of the National Legal Academy, named after Yaroslav Mudry in Kharkiv. He will speak in the first session. He will tell you about the interaction between the Constitutional Court and Administrative Courts. Our foundation is here online. My colleagues, Roslav Rosa and Wolfram Hertig. But here in this room, you also see Hennady Ryzhkov, who is our untiring officer who keeps supporting us in Ukraine. I will stop here, but I want to express all of my heartfelt support to the Ukrainian people. You live in a situation that is hard hard to imagine, but you are showing unprecedented resilience, and please accept our respect to you for that. That's an international seminar. It means that we also have interpreters and simultaneous interpretation. That's why we will ask everyone to speak a little bit slower so they could catch up and interpret for all of us. I wish us all a very good and productive meeting. Thank you. Thank you very much, Ms. Schmeink. And I'm giving the floor at once to Virgilius Valanchis, the senior international expert, support of the integration process in the justice sector component, lead EU project Private Justice, Doctor of Law. Please, Mr. Valanchis.
Доброго дня, мене чутно?
Так, чудово.
Дякую. Ще раз добрий день всім учасникам сьогоднішнього семінару.
Good morning to everyone participating in this workshop. On behalf of the Pravo Justice project funded by the European Union, I would like to welcome all the participants. The way I see it, such workshops are especially important. I heard earlier today that among the audience we have judges not just of the first, second instance of courts of appeal, but also students. And this is crucial to have a young generation wanting to learn about all these issues, especially when we are moving towards the EU accession. I still remember the end of 2004. Back then, I was the president of the Supreme Court of Lithuania, and we had a delegation of the Higher Administrative Court of Ukraine visiting us there, and since then, we have had quite constructive and fruitful cooperation lasting until today. I am especially grateful to the leader, Miroslava. You were very right. Mihailo Smokovich, the leader of the higher administrative legislature, for all your enthusiasm. You might not be aware that more than 10 years ago, he was a deputy president of the High Administrative Court, and he signed a letter on the interpretation and application of the EU law by the administrative courts and judges. It was right after the signing of the association agreement between Ukraine and EU, and it was the correct move, and we still work on that. Our project, Pravo Justice, together with judges of Cassation Administrative Court, has organized a series of webinars and seminars in 2025 on the application of the law on administrative procedure. We know that on the 15th of December, we will celebrate 2 years from the date when this law came into effect. The government will report before the parliament about this law. And yet, what we have observed during this series of events that we had in different regions, Odessa, Chernivtsi, Lviv, Kiev, and others, at the beginning, a limited number of judges and their assistants had a knowledge about this very important law for the administrative procedure. In order to ensure rule of law, because we know that administrative procedure is a leader, a flagship among all the court jurisdictions of the state. ensuring relevant control over subjects of power, public administrations. And this is especially important in the light of the EU accession processes and in order to implement the 3 roadmaps approved by the government in May 2025. The topic we are discussing today, or rather a few different topics that fall under Article 7 of this very important code of laws, they are all very interesting, very useful, and I can see we have quite a good panel of experts. I would like to thank Angela Schmank and IRZ for inviting the best German experts, because we know that Germany is one of the leaders of administrative justice in Europe. So thank you again for the possibility to be here with you, for the possibility to share our opinions. I will be speaking about a few things a little later. If we speak about practice or practical positions, as you call it in Ukraine, of the European Court of Human Rights, especially about the so-called filters, when a first instance judge can see there is a problem with the constitutionality of a law. However, he or she needs to go through the filter of this plenum of the Constitutional Court. This is a very interesting topic, and we will look into how this is done at the level of the European Court, because I can see a certain link, if I can call it that way, because there are several similar positions discovered by the Court of Justice in that several member states are also unfortunately trying to filter or limit the opportunity for judges in those member states that have a right or sometimes an obligation to refer to the Court of Justice on the issues of the law of the EU. I wish to all the speakers and the members of the audience a fruitful day. Slava Ukraini. Thank you so much. Ladies and gentlemen, I think this is my time to remind you that this webinar is quite symbolic, because this is exactly the time when we celebrate 20 years from the adoption of the Code of Administrative Procedure, and our event is a logical continuation of a series of events that we organized in order to share professional experience and approaches with international experts on protection and administrative justice, implementation of constitutional jurisdiction authorities, legal consequences of deciding and legal act unconstitutional, application of Constitution as direct action, as well as working with constitutional limitations of rights and freedoms. Of course, this is all related to Part 4 of the Code of Administrative Procedure, where a legislator gave us, I would say, unique authorities. If a court concludes that a law or a normative act contradicts the Constitution, the court should not apply that act, however, should apply Constitution as a direct action. And after a ruling in that case, the court should refer to the Constitutional Court in order to decide on the constitutionality of a certain law or a legal act. The above principles of Article 7 mean that, in fact, administrative courts in Ukraine do incidental control related to a specific case that should be applied under the law or another legal act contradicting to the Constitution. Why is today's discussion so important? Because the results will directly affect the protection of human rights who go to court, of the people who go to court when they feel a certain injustice, especially if it goes about social guarantees, benefits, payments, pensions, and allowances. In this category of disputes, the legislation on the implementation of social rights and guarantees remains the most unsystematic. And especially under the martial law, they are quite volatile. When an individual feels injustice and goes to court, indicating a contradiction of a law or other legal act with the Constitution, normally by narrowing or limiting social guarantees by appropriate amendments made to the legislation. Those disputes come up in all categories of disputes, basically. And now we come to the question, does a court have limitations to perform such a review of the inconsistency of a law or another legal act with the Constitution in the framework of this particular dispute, given the existence of constitutional jurisdiction whose decisions are binding? Should the court still presume the constitutionality of laws or other legal acts, given that, in accordance with the principles of the separation of powers into legislative, executive, and judicial, the judicial power, in accordance with the functions assigned to it, acts to implement the Constitution and law? Another question that also arises is whether the conduct of such incidental control by the court, during which it plans to decide which law or other regulatory legal act it plans to apply, will not lead to the court replacing the functions of the legislator, a representative of the will of people. In the context of this competence, how should cooperation or collaboration between administrative and constitutional jurisdictions develop in implementing the principles of the rule of law? And in the search of answers to the questions I just asked, I would like to invite and give the floor for an introductory lecture, Mykola Gnatovsky, judge of the European Court of Human Rights, PhD in law. Mykola, you are welcome to join me up here, and take a seat if you feel more comfortable like that. Are you okay like this? Well, before we begin, let me also say the effectiveness of constitutional and administrative jurisdiction in Ukraine is one of the key factors in establishing the rule of law and trust in the judiciary, which has been stressed enough in the introductory words by our colleagues and international experts. And so I have the following question. Are we fully using our tools to protect human rights, or do we still have a certain potential in the development and interaction between constitutional and administrative jurisdiction? With a view of the fact that the constitutional jurisdiction carries out an abstract control without any relation to a specific legal relation. And then the administrative courts, they carry out all the interpretations of case law that is formulated in the context of the Constitution by the Constitutional Court, and in the practical dimension, it is applied to specific disputes and legal relations. I would like to invite Mykola. We are listening to you. Oh, thank you. Let me begin with thanking Miroslava for her wonderful work in organizing such events that allow us to share our experience and opinions. Welcome everyone who gathered here for another serious talk about this crucial topic for an effective protection of human rights on the national level. So again, thank you very much, Mihailo. Thank you for all your work and for the work of the entire system that you are heading now. Dear judges, dear colleagues, students, dear international colleagues who are with us online, it is a great honor for me to speak in front of such a refined audience, and thank you for having me here. I would like to give my opinion, the opinion coming from Strasbourg. How does it look from the outside, and how I can see the potential and opportunities to improve the interaction between the administrative and constitutional justice in order to work better, even better together, to protect human rights in public legal relations, in situations when we speak about possible infringement of such rights towards a certain individual. When you look at the general parameters of the European Court of Human Rights, you will be able to see the number of complaints regularly submitted against a state, claiming that the rights guaranteed by the European Convention have been infringed. And if you look at the total number of cases in the past years, this will give you a picture with the protection of human rights in a certain state. And here, I think we can say that statistics is the most misleading thing in the world, because these figures on their own do not mean on their own that some states are in a better situations than others in terms of how public administrations protect human rights. However, this statistics is also telling, and we should be making conclusions out of it. How do we get a low number of claims to Strasbourg? There are two main ways. Do not infringe on the human rights. Try to, in the activity of the public administration bodies, try to prevent such situations where there is an infringement of the Convention on Human Rights, and this is basically the basic tradition for all member states and other countries, and all our constitutions include all those convention rights, especially because convention rights are minimum and constitutional rights should be wider and provide more on the national and regional level. And that's exactly how it happens. And everything listed in Chapter 2 of the Ukrainian Constitution, that list is much wider than the rights guaranteed by the European conventions, the same as it happens in our other European countries, even though if it's not in the Constitution, it's in certain parliamentary acts, but these rights are there. Of course, everyone gathered here will be happy if public administrations infringe less on human rights, but there is another way. Another way is more understandable and gives more opportunity to follow the trend, and that's availability of effective legal protection tools on the national level. How do we provide these effective tools of protection? That is our main question, and that is the topic I would like to discuss with you today and share my views on that. What is the potential in the work of administrative and constitutional justice to make the situation better? What happens if there are no such tools? We have people finding no solution on the national level. They come to Strasbourg, putting a Strasbourg court in a situation when they have to serve as a first instance court, and they have to establish facts, and it's impossible to do without the national courts. So it's basically a very bad situation for the international court. Of course, it can come to the venue and start talking to the witnesses or to the parties of the case. We had this in the past, but not anymore because the specifics of this court does not allow us to do that.
And it turns out that such trivial violations of human rights, such as excessive length of proceedings in civil cases or in criminal cases, is a problem for any judicial system, and there would always be exceptions. Even if it's an ideal system, there will be fewer of them, but still there would be situations where something is not working and the case is procrastinated. However, to do that, there are two scenarios. First of all, there are the national remedies that can be used, and then such complaints do not get to Strasbourg, but there is no need in that. And when they come there and the European Court sees that everything has been done on the national level, they would be not admitted at the first stage, and they stay there at that first one judge level. There are many examples of that, but it shows us how important it is to have proper authorities and proper cooperation between the national and international judicial bodies. And at the national level, that's primarily the area of responsibility of administrative courts. And of course, there are more complicated problems and the responsibility of the constitutional courts as well. And in that sense, I'm very happy that such workshops are supported not only on the European level, but by our German colleagues, because Germany is one of the examples. Well, nobody is ideal, nothing is ideal, but it's one of the examples where administrative justice is very well developed, is very strong and effective, and where the constitutional justice also works very clearly and very effectively and usefully for the society and the public relations in the country. What is needed for that? As part of administrative justice, the way I see it, first, legislation that allows the administrative courts to perform their functions. Miroslava has just quoted the Code of Administrative Justice of Ukraine. There is a wonderful progressive provision that we can welcome, and it has been devised in a very good way, really. However, this possibility should really be there, a possibility to use the direct effect provisions, the Constitution, the European Convention of Human Rights, that's decisive for the success of the system. And frankly, the situation where every court is obliged to use international agreements ratified by the parliament, and then the question is whether it can use directly the Constitution. I think it's an absurd question. Evidently, if one can use the European Convention, the case law of the European Court, how not to directly apply the Constitution? This cannot happen. And this is also the legislation that allows one to have compensations, clear law on the algorithm of determining compensation for the victims of whose rights have been violated by the state. The same excessive length of proceedings. There are mechanisms that Europe knows very well that allow one. Yes, the civil court continues to torment itself with the case, but the person who suffers from excessive length would already receive compensation by turning to administrative justice. That's a normal and a positive road. A possibility to turn to the Constitutional Court that has already been mentioned today. I won't go into that, but it's very useful. As regards the Constitutional Court, but the system will work when the constitutional justice would have all the necessary elements, primarily, and that's outside of the legislative amendments. And I have to say that in this audience, first and foremost, for the Constitutional Court, we have to treat the Constitutional Court seriously. We have to finally understand that this is a necessary element with a proper functioning of a state. That's not something that can interfere and not something that create problems. That's the body that is to resolve problems. That's the authority that ensures effectiveness of the Constitution and ensures as well compliance by the state of its international obligations. And it's a necessary link so that the system would function in a way that makes it ready for the country to join the European Union. And that's about the selection of judges, appointment of judges, the secretariat. Not a single court, and especially the Constitutional Court, cannot work without a big professional secretariat that has all the proper methods, that knows how to work with constitutional complaints and so on. Now, about the constitutional complaints. At your events, colleagues, this issue has been brought up many times. Mr. Smakovich talked about that last year in his speech, and other colleagues as well, just as I have to repeat it again. A constitutional complaint is to be full-fledged and effective. In that way, the Constitutional Court would not be turned into a competitor for administrative justice. No, it complements it. And it helps it. The decisions of the Constitutional Court on a constitutional complaint that should not only be related to a person who has taken all the instances of the national justice system and an unconstitutional law has been applied to it, and that's the only scenario when it can work, but it has to cover all options, all kind of legal acts, all sources of law that have been applied in a way that violates constitutional rights of a person. And in that sense, Germany gives us a very good example. The Czech Republic gives us a wonderful example, as well as a very good example as provided by Spain with its amparo procedure. All of it is working. Ukraine as a country that is to proceed to this model, or that should proceed to this model, it can give a very attentive look to the experience of Turkey that has adopted this model. And I can speak a lot about how that happened, but probably that's not the good time for it, and that's not the focus of our meeting today, but it is working there. Hungary, in the same way that reformed his system, it looked very much like the system we had in Ukraine before 2011. After the reform, the Hungarian system has turned the Constitutional Court into an effective means of constitutional protection. Is the experience that should not only be studied but applied as well. And I'm convinced that with a proper understanding of this need, with the goodwill of all the stakeholders, this will work very well. And therefore, the capacity to improve the potential of human rights protection and the work of both constitutional and administrative justices. Thank you for attention. Colleagues, we will keep moving. We now proceed to the first session, which is called the limitation of competence in determining constitutionality of a law or another legal act, types of constitutional review. I'm sorry. Before I say a couple of words, I will ask the participants of this first panel to be prepared. In the first session, we're going to have Dr. Brocker, François Lievre, Alexander Vodyanikov, please come here to the stage, and Oleg Kurivenda, Judge of the Grand Chamber of the Supreme Court. Please come up here to the stage, take your seats. Still for the beginning, in this session that is called the limitation of competences in determining constitutionality of a law or another legal act, types of constitutional review and legal consequences, I will continue what I said at the beginning, and let me emphasize that this is an important subject matter, and primarily because of this delimitation of competences, which we have said many times today. The limitation of competences between the constitutional administrative courts, because on the one hand, they belong to one branch of power, and they have the most important leading role in the ensuring of the rule of law. But on the other hand, the Constitutional Court, unlike the Administrative Court, still has its own peculiarities as regards its functions and its powers that does not allow us to treat it as a usual court in its usual meaning. That's why sometimes this court, because of its unique nature, is often treated not only as a constitutional oversight authority, but as a kind of a fourth power, which is above all the other government authorities because of the importance of its decisions. And in that respect, can we say that the Constitutional Court of Ukraine only checks the laws or other legal acts in an abstract way to see whether it complies with the Constitution? Moving away from specific legal relations, and the Administrative Court gets into specific legal relations, whether the court should take into account the specialization of the other court while deciding whether a law contradicts another law, whether there is a contradiction in the law or another legal act. And I'm inviting our great friend of the administrative justice, Lars Brocker, President of the Constitutional Court, President of the Higher Administrative Court of Rhineland-Pfalz, Doctor of Law, please. Thank you.
Herzlichen Dank. Ich hoffe, Sie können mich gut verstehen.
Thank you very much. I hope you can hear me well.
Beginnen mit einem besonderen Dank.
Well, let me start. First of all, I want to thank Mr. Smakovich for the invitation to participate in this workshop to discuss such an important subject. and for many years of our cooperation between our courts. And I also want to thank you for all the meetings that we have had. I also want to thank Angela Schmeing for the invitation. And I want to thank Ms. Bielig, who moderates this meeting so well and who formulates very clear questions. I also want to thank Hennady Ryzhkov, who gives me always good advice how to better understand the Ukrainian administrative justice, administrative law. Thanks to his support, I have been able to assess the Ukrainian law and the work of the administrative justice system. But once I would like to say that we have to be very careful you have to treat my assessment very carefully and cautiously, because I'm only guided by the texts that I have received in translation, and I will try to make this comparison. At the beginning, I want to say that the constitutional justice and administrative justice, they have very special relations. The administrative courts are to ensure, according to their constitutional duty, guarantee uninterrupted legal protection of people against the state, and therefore they need to apply the Constitution accordingly. And that means that they're the so-called everyday constitutional courts. And according to that, they also form a certain alliance with the administrative justice, and those two justice systems, they have to support each other. But it also shows, and your conference, your workshop also shows that sometimes there are some gray zones, because in fact, when we speak about recognition of a constitutionality of a law, then the very first role, of course, stays with the constitutional courts. However, administrative courts, they also get issues where they have, in practical terms, decide whether the laws are constitutional. And that means that both courts, they jointly weave the fabric of justice, as they say. At the same time, it is very important to ensure the powers of the Constitutional Court as a interpreter of the Constitution. And here there are also many procedural tools. The central one is the specific oversight or control of the norms. In other words, these are petitions or complaints in a specific court case, questions about certain legislative provision that is important to solve a conflict for a case, and that's important to have a possibility to bring such complaints or petitions to the Constitutional Court to see whether that law or that provision is constitutional. In general, this specific control of norms, or the judicial petition, as we call it, it has certain objectives, and it's important how it is implemented in practical terms, both in German legislation and the Ukrainian legislation and procedural law. There is that possibility to provide control of those norms, but there are differences in practical terms and about details. And
Sie ist geregelt in Artikel 100 Absatz 1 und setzt etwas voraus,
they have different legal effects. So let me tell you how we see that in Germany. So if we look at Article 100, Part 1 of the main law of Germany, the Constitution, we will see that if the Constitution believes that a law is anti-constitutional and the effect of it is important for a judicial decision, then the proceedings in a case have to be suspended, and a decision of the Federal Constitutional Court is to be received. And here we see that on the one hand, we see here the competence of checking the courts, primarily in terms of parliamentary laws. We see that the courts are to turn to the Constitutional Court to get its decision. According to this article, this check is only applied to parliamentary laws and not bylaws. And if, for example, a Constitutional Court of Germany then decides that a certain law or a certain legal provision is not in line with the Constitution, then the administrative court in this case should not apply that provision. So we see on the one hand there are some restrictions of the competence of the administrative courts. In other words, they cannot but use the law, but they have to turn to the Constitutional Court. On the other hand, we see the monopoly of the Constitutional Court for determining whether a law is constitutional. That is by the Federal Constitutional Court of Germany.
Geht also mit der Richtervorlage, mit der Vorlage der Frage an das Verfassungsgericht die Prüfungskompetenz über. Dieses Modell bezeichnet man auch als konzentrierte oder zentralisierte Norm.
That means that the Constitutional Court cannot work on its own, but it should be referred by another court who acts to consider the constitutionality of a certain law or an act. If we speak about specific cases, we can speak about so-called diffused judicial review, which could be done also by professional regular courts. The objective behind such a judicial referral is as follows: upholding the integrity of the Constitution and preventing the application of unconstitutional laws, safeguarding the authority of the legislature by ensuring that not every court, only the Constitutional Court, may override parliamentary laws, and ensuring the uniformity of jurisprudence in constitutional matters and the creation of legal clarity. A judicial referral, therefore, takes place solely within the context of already pending court proceedings. All specialized courts and the state constitutional courts are entitled to refer a case. Then the court decides to suspend the procedure and refer to the Constitutional Court to render a certain norm unconstitutional. The Federal Constitutional Court decides in an independent interim procedure. It does not serve individual legal protection in a legal specific case. The Constitutional Court does not decide, or at most indirectly decides, the original case. This remains solely the responsibility of the referring court. It means a lot of work if it were to decide on an individual case. That is why the review is done on the parliamentary law referred by the court. If the court is sure that a law is unconstitutional, it has to justify it. It's not enough to just state that it's unconstitutional, it has to be sufficiently substantiated. The referring court must explain why, in its view, a constitutionally compliant interpretation of the provision is not possible. As you can see, that what we see, there is a so-called preliminary review by a specialized court whether a law is constitutional or not, and it happens in cases where citizens claim a law is unconstitutional, and then the judge begins the proceeding. The famous 20th century lawyer said that judges should review constitutional laws based on the procedure of their case. We are obliged to do this review fully. And not only when it's obviously unconstitutional, but even when there is a chance it might be unconstitutional. When we went to school, we learned that we need to be able to see, for example, a law on the salary to public officers is unconstitutional because these payments were too low compared to social benefits. So this was referred to the Constitutional Court. The court stopped their proceedings, and we are now waiting for the decision of the Constitutional Court. This was preceded by a lot of work to make this proceeding and to justify the suspension of the proceedings, and to give time to the parties of the case to voice their opinion. Now we have substantiated that the law is unconstitutional, and now they will need to make a decision. We will speak more detail about this case during the Q&A session. The court referral should justify that the Constitutional Court should only consider this case and review this norm and come up with either a positive decision, or if the interpretation of the norm is incompatible with the Constitution. In the other case, the Constitutional Court may decide that a law is fully or completely incompatible with the Constitution, and the decision is binding. It means that the legislator, the public administration, should implement the decision made by the Constitutional Court. The Federal Constitutional Court, whenever the proceeding resumes, the decision is made on the specific case. If the decision was made that a regulation is constitutional, we as a court have to agree to it, and in our decision on the case, we should implement the relevant decision of the Constitutional Court. This means we need to comply with the Constitutional Court decision. Let me speak about the referral by the judges to the Constitutional Court of Ukraine under Article 7, Section 4 of the Ukrainian Code of Administrative Procedure. It was especially interesting for me to see Article 7, Part 3. There is a similar referral to the Constitutional Court there. However, the concept used is a little different in Germany. The core objective of the judge's proposal is also to safeguard the integrity of the Constitution and to prevent for the future the application of unconstitutional law. At the same time, it aims to ensure the uniformity of jurisprudence, particularly in constitutional matters, and to create legal clarity, a pacifying function. Under the Ukrainian law, a judicial referral is also a concrete form of judicial review, meaning that it requires a specific legal dispute in which the question of the validity of this norm is decisive. The crucial difference, however, lies in the fact that the review procedure initiated by the Court of First Instance before the Constitutional Court is not designed as an intermediate procedure, but rather follows the final decision of the Administrative Court. I'm not going to speak on point 4, but rather on paragraph 3, where in the event of a conflict between a legal act and the Constitution of Ukraine, the court shall apply the legal act which has a higher legal force. This construct follows the model of deconcentrated judicial review, which leaves the decisions on the constitutionality of parliamentary laws to the specialized courts. Thus, neither the authority of the parliamentary legislature is safeguarded, nor is constitutional jurisdiction activated for the specific case. I still don't understand what in this context the application of Constitution means. For us, we have to make a decision on a case, but applying Constitution means that when we come to a conclusion that a norm is unconstitutional, in that case, we have to use the past case law. If we can justify that a norm is unconstitutional, we look into the practice before this norm came into effect. And Article 7, Part 3 seems very similar to that. It means that the administrative court can also have a so-called legislative function. It's something we are all very interested in. It might be overstepping our competences in regard to other public administrations. Another interesting thing for me is sentence 2, paragraph 4, where it speaks on the legal clarity for the follow-up procedure to be initiated by the respective administrative court after its final decision. It's interesting that the referral of the provision deemed unconstitutional to the Constitutional Court is done via the Supreme Court. We can see that here the Constitutional Court also has to take part in this procedure. However, my interpretation of the provision, which is only a preliminary assessment, the administrative court is obligated in the case to initiate the review procedure. The court refers the matter. Which court initiates the procedure is already a matter of interpretation. Logically, this obligation would only fall on the court that rendered the final decision in the specific dispute. This is because there is no need for a constitutional review beforehand, or the need ceases to exist. For example, if a first instance decision is overturned by the appeal court and the latter considers the norm to be constitutional. Of course, this issue could be also settled in the Supreme Court, which is a sort of a filter. The administrative court can or is obliged to only initiate the proceedings, but cannot itself refer the matter to the Constitutional Court. It does not have a monopoly. It belongs to the Supreme Court. This is certainly a sustainable instrument for ensuring the uniformity and legal certainty of administrative law, which primarily rests with the administrative courts. At the same time, this procedure relieves the Constitutional Court of its burden, as not every individual court can readily initiate a review proceeding before the Constitutional Court. The procedure in Ukraine relieves the burden on the Constitutional Court. The Supreme Court also bears a significant responsibility, as it ultimately decides as a gatekeeper on access to the Constitutional Court. According to its wording, the law does not provide the Supreme Court with clear guidelines on the criteria it must use to decide on the referral. Two possibilities are already apparent. First, the Supreme Court is only required to refer the matter if it is itself convinced of the unconstitutionality of the provision. This would mean a relief for the Constitutional Court of its burden, but conversely, it would also considerably restrict its scope of action. Second, the Supreme Court must be convinced, based on the referral order from the Administrative Court, that the question of the constitutionality of the submitted law requires clarification. This would only be the case, for example, if the question appears at least doubtful after its own examination and cannot be readily answered based on the law and the existing case law of the Constitutional Court. The latter standard seems preferable to me, at least from a practical point of view, as it opens the way more readily to generally binding decisions by the Constitutional Court. Furthermore, it would be advisable for the Supreme Court to transmit its decision on whether or not to refer a case to all administrative courts in a standardized format, if this is not already happening, so that they can take the considerations into account in their practice. This can also contribute to the further development and harmonization of case law. A key subsequent problem, which has already been discussed at several conferences, and which I therefore only want to touch upon briefly today, is how the effect and observance of the Constitutional Court's final decision in the subsequent proceedings can be ensured in practice. The decisions by courts of the first and second instance should be taken into account by the appropriate courts, because this brings a better development of the law and the case law as well. In Germany, we refer not only to the Federal Constitutional Court, but also to the European Court of Justice in certain cases, in order to unify the jurisprudence in the EU. Another question that has been discussed at many previous conferences is how to provide that the Constitutional Court's decision can also have an effect on the original case, or based on the principles of legal certainty and legal peace, the parties to the original case cannot benefit from the Constitutional Court's decision, positively or negatively. Under German law, at least, there would be no automatic reopening of this comparable proceedings by the administration, and certainly not by the administrative courts, as I have already explained in detail before. What happens next? Let's say the Constitutional Court decides that a certain law is constitutional, then a citizen can say, well, bad luck, at least I have had a decision serving my interest. At the end, let me say the following. The instrument of judicial referral to the Constitutional Court is comparable between German and Ukrainian law, but by no means identical in structure. The concentrated German model and deconcentrated model in Ukraine of the judicial review have both advantages and disadvantages. In Germany, we suspend the proceedings, and the proceedings on constitutional referral begins, and it could last a little longer. On the contrary, in Ukraine, when a decision is made, it's done on an individual case faster, and only then it is referred to the Constitutional Court. The problems arising from the subsequent constitutional review under Article 7 of the Ukrainian Administrative Court procedure, in my opinion, could be mitigated by minor adjustments to the wording of the law, provided this were politically acceptable. For example, the Supreme Court's gatekeeper role could be significantly reduced by having the referral process go through the Supreme Court, not by the court itself. This means the Supreme Court would merely forward the administrative court's referral decision, but could add its own statement. There are historical precedents in Germany. A special provision for exceptionally setting aside a final decision could also be considered if the Constitutional Court answers the question of a law's constitutionality differently than the referring court, so that at least the parties to the original proceedings could benefit from the referral and the review by the Constitutional Court. However, there are certainly other options to consider. The sensitive yet crucial interplay between constitutional and administrative courts and their alliance still raises numerous questions. Let me wish you a lot of strength and inspiration in developing constitutional and administrative courts. Thank you for cooperating with Germany.
Thank you very much. Now, the next speech. For the first time, we have a French expert with us. This is advisor to the Council of State, associate professor, Department of Law, Paris-Nanterre University, François Lelièvre. Mr. Lelièvre, as much time as I had to read a little bit about the situation with the constitutional control system in France, constitutional review function, and I found an interesting thing there, that before 2010 you only had the preliminary control, and I understand that the laws that were to be reviewed to see whether they were constitutional, they would get to the Constitutional Council or to the State Council before they would be approved. And I had a feeling that perhaps in the French culture, a law is something sacred that is very difficult to violate. Therefore, as your system has changed after 2010, and you also, your courts are somewhat similar to the German system that can suspend proceedings first and only then the case may be decided. Can you please share your experience? We are very happy that you're here for the first time, and we hope to have more cooperation in the future. Thank you very much.
Thank you. Yes, we share in some aspects of the German system with suspension of the proceedings and then referring to the Constitutional Council. To begin with, I would like to emphasize the great honor it is for me to speak in front of you. And yes, I will address the following topic: the review of the constitutionality of a legislative provision in France, the respective roles of the courts of first instance, the courts of appeal, Supreme Courts, and the Constitutional Council. So, first, part one would be a very brief presentation of the French court system. Then I will present the shortcomings of the constitutional review of laws before 2010, and then the current system. Part one, brief presentation of the French courts. We have two Supreme Courts, the Constitutional Council of State, the Court of Cassation, and then a Constitutional Court, the Constitutional Council. So very classically, the Council of State has jurisdiction over disputes between a public body and a private entity. The cases are first judged by the administrative courts, then they may be appealed to the Administrative Court of Appeal, and then the final decisions of the Administrative Courts of Appeal may themselves be appealed in front of the Council of State. And regulatory acts adopted by the government can be directly challenged in front of the Council of State. Now, the Court of Cassation has jurisdiction to hear cases in civil, commercial, social, or criminal matters. The cases are first judged by the courts of first instance, then may be appealed to a court of appeal, and then the final decisions of the courts of first instance or decisions of the Court of Appeals may themselves be appealed to the Court of Cassation. Then we have the Constitutional Council. The Constitutional Council is not a Supreme Court that is superior to the Council of State or the Court of Cassation. I think you have the same system in Ukraine, as I understand. The Constitutional Council cannot be seized directly by the citizens. It is a court vested with various powers, including, in particular, the review of the constitutionality of legislation adopted by the Parliament. The Constitutional Council does not have the power to quash an individual act or a regulatory act adopted by the government or public bodies in general, which I think is different also from the system in Ukraine. In France, only the administrative judges can annul an individual act or a regulatory act adopted by the government that is contrary to the Constitution. Now I address part two of my speech before 2010. And the shortcomings of the constitutional review of laws. Before 2010, the Constitutional Council had only the power to act ex ante, prior to the entry into force of the law. The Constitutional Council may be seized of a law adopted by the Parliament prior to its entry in force by the following persons: the President of the Republic, the Prime Minister, the President of the National Assembly or the Senate, or at least 60 members of the National Assembly or 60 senators. In practice, in most cases, the Constitutional Council is seized by members of the Parliament that oppose the government. So it's a tool for the opposition. The Constitutional Council has to rule very fast, only 1 month to rule on the conformity of the law to the Constitution. And if the government says that it is urgent, then the Constitutional Council has only 8 days. Now we had a problem with this review of the law, because for various political reasons, opposition members of the Parliament do not always challenge the constitutionality of a law prior to its enactment. Opposition members have a limited time to write their application to the Constitutional Council and do not always raise the proper arguments to convince the Constitutional Council that a law is contrary to the Constitution. And of course, factual circumstances can change years after the enactment of the law. All this system before 2010 led to a situation whereby once into force, a law adopted by the Parliament was valid, even if it was potentially contrary to the Constitution. Another drawback of the system is the following: individual and regulatory acts that were of direct implementation of the law remained valid, although they were contrary to the Constitution. Why? Because administrative judges, namely, refused to annul them for the reason that an annulment amounted to declare the law itself contrary to the Constitution. Now we're coming to the last part of my speech about the current system. Ex post review of the Constitution. I have to stress that the ex ante review still functions. Now, since 2010, the Constitutional Council may consider whether a legislative provision which is already in force violates the rights and freedoms guaranteed under the Constitution. This preliminary ruling on the issue of constitutionality functions as follows. Constitutional review is conducted on the initiative of an applicant, since the question is raised by an application filed during proceedings before any time of court: civil court, administrative court, criminal court. To give an example, if a taxpayer thinks that the taxes he or she has to pay are illegal because they are based on a law that is contrary to the Constitution, he or she seizes an administrative court so that the court quashes the taxes. Then the applicant has to submit a specific application that is only focused on the constitutionality of the law. Why a specific application? Because in practice, this helps the court to identify quickly the question right from the beginning. It's not one line on all the proceedings, it's one application on this topic. The court has to decide whether the issue of the constitutionality of the law challenged by the applicant is applicable to the dispute. To sum up, the court has to reject as inadmissible an application that has nothing to do with the dispute. Then at this stage, there are 2 successive filters. First filter, courts of first instance and court of appeal have to decide whether the application for a priority preliminary ruling on the issue of constitutionality is, I quote, lacking serious merit. To say it bluntly, if there is at least a very small chance that the applicant is right, then the court has to refer the application for priority ruling on the issue of constitutionality to the Supreme Court. Courts of first instance and courts of appeal have to refer the application without delay, says the law, which means a few days only. So like in Germany, as I understand, the courts stop the proceedings on the main case. And then they have to refer to the Supreme Court in only a few days, in practice, maybe 10 days. Then they go to that's the second filter, to the Supreme Court, either the Council of State or the Court of Cassation. And they have to decide whether the application for priority ruling on the issue of constitutionality is, I quote, serious. If it is serious, then the Supreme Court refer the application to the Constitutional Council. Then the Supreme Courts have only 3 months to decide. Only 3 months. If they do not rule within this 3-month period, the application is automatically transferred to the Constitutional Council. It is possible for an applicant to claim that the law is contrary to the Constitution for the first time in front of the Court of Appeal, or even for the first time in front of the Supreme Court. Then the Constitutional Council has 3 months to rule on the issue of constitutionality. So in conclusion, we have this system whereby, first of all, the Constitutional Council has a monopoly on the issue of the constitutionality of the law, which I think is relatively different from the Ukraine system, as I understand it. A citizen can only reach the Constitutional Council in the course of a trial in front of a court. And then, which is very important, so the procedure is meant to be very, very quick. So you heard only a few days in front of the the first instance courts or courts of appeal, then 3 months in front of the Supreme Court, and then the Constitutional Council itself has only 3 months. So in total, it's not more than 6 months. You stop the proceedings only for 6 months, and then you have the final decision of the Constitutional Council. So this system can only work if the courts abide by the deadlines, and I can assure you that they do. And second, that ordinary courts, and especially the Supreme Courts, do not block serious questions. So they have to be loyal to the Constitutional Council, and I think that's what we do. Thank you for your attention.
Щиро дякуємо.
Thank you very much, Mr. Leftev.
І зараз ми
Now we keep moving, and we are now going
наступний доповідач
to have Alexander Vodyannikov, the next speaker. I'm very happy to see you at this event in your new quality as a judge of the Constitutional Court of Ukraine. And on behalf of all of our team, we congratulate you. It's a great honor that for us to have you with us today. Mr. Vodyannikov, it's an interesting subject. I think it's going to take a central place in this discussion now, because it is somehow treated that the presumption of constitutionality of legal acts is not absolute. That it is possible to go outside of that presumption. In what situation is that possible? When, for example, it is clear that a law does not conform to the Constitution, there is no need to provide a good legal analysis, which is the which is the competence of the Constitutional Court. And for some reason, some people believe that it's only that body that can do such an assessment, because everyone knows what the competition is, the selection of the judges for the Constitutional Court, what unique knowledge those judges have, what methods they use, and looking at the status of the legal acts, starting with the Constitution that they interpret and fill. Perhaps it's not accidental that judges are only elected for 9 years to get some new blood into the to further develop the law and thus even help a constitution to remain a living organism. Please. Thank you, Miroslava. And the first thing, I would like to thank you for your kind words. I also want to thank you for our possibility to speak at this very important practical workshop, because it's true that the issues, the questions you were asking, the things we're discussing, according to the agenda, are really very relevant and such that have this kind of a cross-dimensional value that are not only limited to administrative justice or some specific cases. Today, I'd like to make a brief intervention, I hope within 10 minutes, about the role of the presumption of constitutionality in delineating competences between administrative courts and the Constitutional Court. We don't have a clicker. Please, next slide. I'd like to start by saying that the continental system that we have in Ukraine and in Germany as well, and I'm very happy that our German colleague has already mentioned that, and once again I'd like you to remember what he said. So the continental system gives the constitutional jurisdiction body that has exclusive competence already has a kind of a limited competence. First of all, it is based on the very idea of the only constitutional jurisdiction body. When we talk about its competence and the jurisdiction of it, clearly that there are certain areas that are not covered by its competence. Same in Ukraine, and we'll talk about that. And the other thing is that the Constitution suggests that we have the supremacy of direct effect, direct action. So the courts are to use the Constitution as an act of direct effect. And these two principles, basic principles, already point to the fact that there is no absolute monopoly of the Constitutional Court as regards the Constitution, deciding on the constitutionality of legal acts. And that creates a certain paradox for the continental model of constitutional review. Why? Because on the one hand, the Kelsen model that we have here, and in Germany as well, it only speaks about exclusive competence. At the same time, that exclusivity means that there are certain areas, certain relations that are not covered by the Constitutional Court's jurisdiction as single body. After the Second World War, we can speak about the new paradigm of constitutionalism, which is based on the recognition of the fact that human rights are priority rights, are legal rights. If you open up wonderful treatise of the French administrative law of the times of the Third Republic, you will see that they provide an answer to this wonderful question about why constitutional rights do not have a legal content. And in fact, this is a paradox of the current model of constitutional jurisdiction, which is that in spite of the fact that there is a single authority, but ordinary courts have their own role in the constitutional review.
Naturally, that asks a question about the delineation of competences between the constitutional courts and other courts, especially administrative. Next slide. Next slide, please. In order to answer the question about this paradox, I suggest we go to the constitutionality presumption, which is a key element of our constitutional order. The constitutionality presumption was adopted by the Constitutional Court back in 1997 as a fundamental to our jurisdiction, and it means that any normative or legal act is considered to be compliant with the Constitution of Ukraine and has a legal effect before it is decided as unconstitutional by a special constitutional review body. So what does it mean for our question about the delineation of competences? Let's look at the next slide. The constitutionality presumption obliges everyone, including the Constitutional Court and other courts, to apply laws and legal acts unless they have been considered unconstitutional. However, there is only Article 8, Part 3 of the Constitution, infringement of freedoms and rights. So, number one, that would be conforming interpretation. The courts have to select such an interpretation that is conforming with the Constitution, complies with the Constitution. It means that ordinary courts, the courts in the jurisdiction system, the ordinary courts should carry out constitutional review, and in the course of that review, they should select the interpretation compliant with the Constitution. If such interpretation is impossible, there is a pretext for canceling such a presumption. So what happens then? Constitutional presumption, just as any others, it could be strong or weak. A strong presumption applies to two categories: the laws of Ukraine and international agreements ratified by the Parliament. The weaker presumption applies to other legal acts that are applied by the court. Why? A presumption could be strong. And there are two main provisions here. Number one is based on Article 1, the principle of democratic states. It means respect to the power and will of the people represented by the Верховна Рада, the Parliament of Ukraine. Mykola Kozubra, the judge of the Constitutional Court, said that such a leading role should create a foundation for the unity and internal correspondence of the entire system of normative acts, which is one of the main requirements of the rule of law. Another principle under Article 7 is a principle of separation of powers. We stay within those authorities that are established by the Constitution and the laws of Ukraine. Next slide. A weaker presumption also arises, and it's already there in the Constitution, and ordinary courts already apply it. That is Article 19, speaking about the direct application, and all the principles I'm giving you here are from the case law of the Constitutional Court. Next slide brings us back to the situation when the conforming interpretation is impossible. What will the courts do in this case? How do they cancel this presumption of constitutionality? The first principle, the norm of the law, should relate to the constitutional rights and freedoms. Why? We have Article 8, Part 3, of course, but there is another thing, other questions of the compliance with the norms of the Constitution are exclusively in the competence of the Constitutional Court, which means a general jurisdiction court cannot establish the violation of the principle of the separation of powers or decide on some other constitutional things which are not included in the Constitution. A second principle is presumption of constitutionality cannot be cancelled by the courts unless the Constitutional Court of Ukraine has already spoken. There's already a decision about the application by the courts, and this arises from Article 151-2 of the Constitution of Ukraine. And the second case, if there is a legal position of the Constitutional Court, application of which to a norm definitely leads to the conclusion on its non-compliance with the Constitution. If we compare it to the French doctrine, that would be acte clair and acte éclairé. This brings us to three types of authorities of the judges, and that would be complementary constitutional review, that would be application of that conforming interpretation, which brings us to the compliance with the norms of the Constitution. The second one is incidental or casual constitutional review. That's what we spoke about today. If the court decides something is not compliant with the Constitution, it refers to the Constitutional Court, to the Supreme Court of Ukraine. However, such a review does not lead to the conclusion of unconstitutionality of the act, only not application of the act. And this is a question now to the Supreme Court. Number one, when a court, any court, first instance, second instance, a court of cassation, saw that there are certain problems, that is already a direct way to the Constitutional Court. There could be no situation where a court saw there was a problem, they referred a case to the Constitutional Court, and the Constitutional Court does not accept it. That's not correct. Now, this is our competence of the Constitutional Court, not of the plenum. Why do plenum take over? Why does it take over our competence? Whether deciding whether something complies or does not comply or something. But this is not the topic of our discussion today. We will come back to this in the second part. And number three is direct constitutional review. Sometimes we disregard this. However, there is a huge number of legal acts. Well, administrative courts do pay attention to this. However, the researchers not always consider this competence. So this is review on the acts who do not belong to the competence of the Constitutional Court of Ukraine. And next slide. By implementing these three competences on assessment and review, we need to remember the sui generis of such competences of courts based on the continental system that we have. Number one, only our decisions of the Constitutional Court have effect, or it could be done by administrative courts on certain normative acts that are within the jurisdiction of those courts. Otherwise, the ordinary courts decisions have the inter partes effect. Now, another question is not just the separation of powers. It's an important element of the constitutional order, and this constitutionality is an exclusive jurisdiction of the Constitutional Court. And number three, we are working on the principle of court dialogue between the courts and the Constitutional Court. And this dialogue should be between equal parties. Why? The courts raise questions that later come to the Constitutional Court for a constitutional review. And here is my chance to thank you. Well, thank you. Thank you, Alexander. We have our last presentation, and I'm happy to present to you the judge of the Grand Chamber of the Supreme Court, a representative of the Administrative Justice, Oleg. We wanted to have you today here because the Grand Chamber of the Supreme Court is charged with the provision of unity of the judicial system. You have had quite a long experience of work in the administrative justice. Based on the principles of Article 7, could you share the approaches and principles that the Grand Chamber uses when applying norms of the Constitution as direct actions? Could you share something with us? Dear colleagues, it is my great pleasure to be part of this event because both professional lawyers, scholars of the constitutional law, and young students are aware of how important today's topic is for the development of Ukraine as a European state. We have heard quite interesting presentations here, and all the statements we have heard today should have a practical application. The Grand Chamber takes all these questions with great seriousness on applying norms of the Constitution as direct action, because it is for the Grand Chamber to develop the unity of judicial practice, and based on the conclusions of the Grand Chamber, this practice takes its direction, its clarity, because all courts of the first instance applying that decision, they need to understand it and to respect it. And the way the Grand Chamber formulates those decisions should be clear. The first cause of this importance of the application of Article 7 of the Code of Administrative Procedure is related to the quality of laws adopted by our Верховна Рада. The Parliament understands that the laws need to comply with the Constitution. However, there are some laws adopted that later need to be reviewed and decided unconstitutional. However, every member of Parliament should be aware of the mission. Whenever they take their oath, they obliged to comply with the Constitution and the laws of Ukraine. However, I understand that until we have Article 7 of the Code of Administrative Procedure, and until we have the law that the constitutional courts speak about, there will be still a lot of work for us. Let's speak about the practice of the Grand Chamber of the Supreme Court. And I think most of the colleagues present here know about it. We adopted in May of this year a decision that shows the specificity of applying Article 7, the problems arising out of it, the problems arising out of application of the direct action of the constitutional norms, and about the problems seen by the courts but which are unable to solve. In May, we have looked at the exemplary case. An exemplary case is the petitioner comes to the first instance court, and a judge sees that there might be a lot of similar cases around the country, and under Article 290 of the Administrative Court, they refer it to the Supreme Court. And then this decision of the first instance court is reviewed by the Grand Chamber. And that was exactly the case. The topic was very sensitive. It was about the social protection of the people who were injured during the war. We are living in the times of military aggression, and a lot of attention is paid to the protection of people who suffered some losses or damages from the war. However, a certain protection is guaranteed. It cannot be limited for people who sacrifice their lives and health for the defense of our country. So the claimant was a person with disability as a result of the war, and the claim was that a one-time monetary allowance that was accrued for him was not under the law of social benefits. That allowance should be 16,000 hryvnias, and he received 2,900, 5 times less under the most recent amendment to the law. The Grand Chamber did not agree with the conclusions of the Supreme Court. The Supreme Court said that this benefit was introduced in 1999, and until 2025 there were problems in paying that allowance. The veterans and disabled people came to the courts took decisions, the Supreme Court reviewed those decisions and deemed them deemed unconstitutional changes to the law on the state budget. And unconstitutional was also the amendments on the procedure of payment of those benefits, and that it should be in the administration of the Cabinet of Ministers. By the time the law was adopted in 2023, there was a law under which a disabled person had to receive a minimum of 8 pensions. And here, the chamber found a solution to that situation, and the court had to consider this case. The law says that those individuals have a right for such one-time allowance before the 1st of May annually. It was the victory date for us, and this was the amount of that benefit established. However, the Verkhovna Rada amended Article 13 of that law, saying that it should not be a one-time benefit, but it should be a one-time payment before the independence date. So everything remains the same. The subject of that benefit and the amount is the same. However, this allowance should be paid under the decree of the Cabinet of Ministers of Ukraine. Of course, the claimants, not just the one I speak about, they came to the court and we had a very difficult question to decide. We saw the infringement of principles of social fairness, the human rights, and the Supreme Court had to find a way to protect those rights. The solution was that the Constitutional Court mentioned it several times, that the freedoms cannot be limited, and it was decided that the rights under Article 46 of the Constitution of Ukraine should be protected, and the constitutional norms should be applied as a direct action, and this payment should be paid in the previous amount under the law before the amendments of the 15 April 2023.
The court was appealed by the Grand Chamber because the Supreme Court did not accept that judgment and it provided its argument. Well, it turned to the Grand Chamber. The same issue that the Supreme Court faced, the Grand Chamber it faced, and the Grand Chamber did not agree with that decision. Based on its conclusions, in particular the ones that we've heard from the judge of the Constitutional Court and by our international participants, namely, that one-off allowance that decision was concerned about is not in the Constitution, a guarantee that is to be protected by the Constitution. Article 46 of the Constitution says there is a right to social security, social protection guaranteed by the Constitution if a person becomes disabled or if in case of unemployment. However, it does not speak about this kind of aid that case was about. And the other cases can be found in the laws of Ukraine. So what was the Grand Chamber based on when hearing that case? First of all, a detailed analysis of the Constitution of Ukraine and the provisions that speak about that protection, as the court, that appealing court believed, and whether this direct effect provisions can be applied in that case. The Grand Chamber found that one-off allowance is not the kind of payment that the Constitution speaks about. That's why the court cannot defend that right by applying a direct effect provision. The Grand Chamber did not agree with the first instance court, meaning that the first instance court applied the Constitution of Ukraine as a direct effect provision, said that the payment should correspond to the previous law before it was amended. In other words, the law that was no longer in effect. The Grand Chamber found that in such a situation as the Supreme Court does not believe that is the law that is anti-constitutional, but the law that has already lost its effect. That's why the Grand Chamber of the Supreme Court found that in that situation, the conclusion that the payment should be made according to the law that had lost its effect cannot be used. In that case, the Grand Chamber quoted the previous decision of the Cassation Court of Appeal, saying that the rights cannot be narrowed down and other social rights cannot be narrowed down. However, the Grand Chamber has its powers, and as Alexander has suggested, there is the delineation of functions of the judiciary, and the Grand Chamber cannot take over the powers of the legislators. As it understands the problem of the case, as it understands that the state treats those people unfairly, the Grand Chamber still had no powers to defend that right, to protect it, and it turned to the plenary of the Supreme Court, and the plenary turned to the Constitutional Court, asking it to interpret whether that law is in conformity with the Constitution. It's difficult to say what the decision of the Constitutional Court is going to be, but in that situation, I believe that the Grand Chamber and the Supreme Court acted within the framework of Article 19 of the Constitution of Ukraine. As an example, when the Grand Chamber applies the Constitution in its direct effect function, there is a case when a person complained that his right to peaceful assemblies had been violated, as there is no law in Ukraine on peaceful assemblies, and according to the law, to Article 39, it should be regulated by the law. There, the Grand Chamber used the Constitution in its direct effect, saying that the person's constitutional rights were violated, and it could render its decision. I believe that the problem is there. It's a serious problem. It's related not only to the quality of law, but unfortunately, the Constitutional Court of Ukraine cannot quickly review those laws to see whether they conform with the Constitution. And perhaps this is the problem, that the Verkhovna Rada of Ukraine, when it adopts a law, it understands that, for example, in a certain case, it should understand that they are repeating the same mistakes that have already been corrected by the Constitutional Court. But as there is no other way to restrict those social payments, and that the court cannot rectify it, and the Constitutional Court, in this case, can take quite a lot of time, the parliamentarians believe that they can adopt such laws. So the very first thing that should be done in this area, I believe, is the quality of the legislation. And the legislators should understand that if a law has been adopted and they have to act according to the Constitution, they have to treat adoption of the laws in a responsible way. Another thing, if the Constitutional Court receives a request about those rights, I believe that the Constitutional Court would also be able to make decisions, fast decisions, because the fewer constitutional complaints it gets, the fewer chances will the Parliament have to adopt such laws, and the more trust there will be that there can be fair justice in the country. So I want to say that the Constitutional Court, when it treats the Constitution as the act of direct effect, it has good arguments, but unfortunately its powers are big, but they're not unlimited. So we have other things to work on, and I hope that this Article 7 of the Code of Administrative Justice will be used for a long time, but it will be used in such a way so that nobody would accuse us of violating the principle of distribution or the limitation of powers. Dear colleagues, we only have a couple of minutes before a very important event in our today's agenda. That is the award ceremony for the winners of our competition. But without a discussion, I feel, awkward vis-a-vis our German partners, for example. We would be able to say that our event has not taken place. So I would allow myself to take a little bit of your time. I'm asking for your understanding, because I think that there are several items that I focused on during those 5 workshops that we have had. And as a result of today's speeches by our national and international experts, in particular my colleagues. First of all, I'd like now to ask a question. And is Mr. Brocker with us yet? I just don't see him on the screen. We don't know. Well, maybe he's no longer with us. Oh, you're with us. Good. Thank you. I will allow myself to say several things, and I would like to ask you to share your considerations, perhaps with account of our legal issues. What should judges do? What do you think? What should we be guided by? What should we take into account in our decision-making in view of the position of Mr. Kruvenda, the latest speaker, who said, well, where the court took the position of the law? What should they do in such situation which we have mentioned many times. When a constitutional court, for example, believes that a provision or a law is unconstitutional, and then sometime later the parliament would still adopt that law. I don't know whether you had a chance to listen to Alexander Vodyannikov, who talked about the presumption of constitutionality. In a way, he said that we cannot violate the constitutional position of the Constitutional Court that has already been made public, right? So, if possible, maybe just in a couple of words, if you are ready, please. Thank you very much for this question. It's a special situation. I can repeat it again that I am confident that I have understood the problem in the right way. It means that the Constitutional Court finds a law unconstitutional while the legislator reacts in such a way that once again it adopts the law that repeats the unconstitutional provision. In the German legislation, we have a ban on a repeat adoption of a legal provision. It means that if the Constitutional Court decides that a law with a certain wording is unconstitutional, then the legislator cannot adopt the same law again. It means that if the new law would be submitted to the Constitutional Court, it will be a very short, quick decision. It would say that the legislator has repeatedly adopted an unconstitutional legal act. So the legislators are also bound by the decisions of the Constitutional Court. That's the central point. It is binding. But of course, the legislators may adopt the same law 5 years later or 10 years later. Then the Constitutional Court will check whether the situation has changed so dramatically, which should justify the legislators' actions. The legislators, in fact, have to confirm that the situation has changed and that they have to adopt that law. Now, as regards that situation about the presumption of constitutionality that my colleague has talked about, I'm thinking about the laws adopted by the parliament. I think now the Ukrainian situation is easier than what we have in Germany. It's easier for you to do that because of your Article 7 of the Code of Administrative Justice, because an administrative court can then say it's evident here that the legislators have just repeated it, but the Constitutional Court has already made that decision, and I'm not going to apply that law. And after that, and after I make that decision, I will once again start the proceedings in the Constitutional Court. And therefore, you have a stronger position where you can tell the legislators that you have not behaved properly. So it's a more practical situation that you have. All right, thank you very much. And I will a couple of more questions. Alexander, would you like to say something? Because I have a different question to you, if you allow me. Well, maybe you can compliment Mr. Broker. I would like you to continue and help us with the following. We have such a controversial issue as to certain decisions of the Constitutional Court that we've been discussing for quite some time, and it's good. We will eventually find the right answers. Maybe you can help us with that. For example, let's say a first or second instance court or a case in cassation. They have opened up a case, and while hearing it in the first or second or third instances, they apply a law or a certain provision that at that time, while the case is being heard, at any instance, when the decision is made by the Constitutional Court, that finds this provision unconstitutional. And according to the Constitution, clearly, the decisions of the Constitutional Court lose effect after they are made. But then the question is, if a provision is deemed anti-constitutional, we're not even talking about how to put off the decision. But in that case, how can one understand that that law or that provision that has lost its effect shall not be applied as of the moment when the decision was made? In view of the situation where the administrative court is deciding on is applying rather the law or provision that existed at the time when those legal relations took place in a case. Do you understand my question? Yes, of course I do. Thank you. It's well, let me start with a brief comment. What my colleague from Germany said about the situation with adoption of a new provision that repeats the provision that has already been found unconstitutional. We have this ban in our constitutional law as well. If you look at the decisions in the law on psychiatry, for example, where the principle was formulated well, and then in several decisions on budget laws, if the legislator repeatedly adopts a provision that has been found unconstitutional, there is no presumption here. It has been thwarted, quashed, in fact. And here, the courts have to apply the Constitution. And it's a direct effect in the light of what the Constitutional Court has said. As regards your situation that you have suggested, a very interesting one. When the proceedings have started in any instance, and then the Constitutional Court makes a decision that finds a provision on which a decision is based unconstitutional, although at the time when certain events took place that are being, for example, appealed, they were constitutional. First of all, we have to look at the arguments for the Constitutional Court and how it found exactly the provision unconstitutional. Moreover, the Constitutional Court can find it for different reasons. We have some substantive reasons, procedural ones, etc. Another thing that I'd like to focus on, colleagues, why do we decide that we have an absolute ban on retroactivity? Even decisions of the Constitutional Court, they take effect as of the time when they are made, which already brings up some questions about this absolute ban on retroactivity. Another thing, if a person comes to a Constitutional Court and has received a decision of the Constitutional Court and then goes to the Supreme Court asking that it be enforced, for some reason, as practice shows, the Supreme Court would reject, the review of the case of the author of the constitutional complaint by saying that the decisions of the Constitutional Court do not have retroactive action according to Article 152. Why don't we look at Article 55 instead? Because we're talking about implementation of one's constitutional right to the constitutional complaint. It's true that in your codes we have gaps, but at the same time, the Supreme Court has the right, and the Grand Chamber has already paid attention to that. There is the analogy to the procedural law. The most similar one is review of the case after judgments of the European Court. That's well regulated. Why not use that? To get back to your question, yes, and what did the Constitutional Court say? If we can interpret that situation in a constitutionally comforting way, then the Constitutional Court, an ordinary court, has to do that. All right, thank you. Mr. Broker, do you remember the question? Are you still with us, Professor? I don't see Mr. Broker. Are you with us? Yes, I'm sorry. Yes, Ms. Bilak. That's Mr. Herdig. He just wrote to me that he had to go away. Unfortunately, right now, we don't have him with us now. Sorry for it. Well, I'm sorry.
Ви хотіли щось поставити запитання?
Did you want to ask a question?
Nein, ich wollte Herrn Brocker noch fragen, ob er vielleicht doch noch im Raume ist, aber ich glaube, ich rufe nochmal, Herr Brocker, sind Sie noch da? Nein, ich glaube, er musste wohl doch
Let
leider
me
schon
ask
gehen.
again if Mr. Broker is here with us. No, he stepped
Ваші
away.
запитання, будь ласка.
Well, I thought you wanted to ask a question.
Питання то в мене є, але
I
дискусія.
have a question.
З приводу рішень Конституційного
It's
суду,
on the decisions of the Constitutional Court and their retrospective application. I know all the judges of the administrative courts remember the decision of the Constitutional Courts on the decisions of certain provisions of the law on Ukraine on the state budget for 2007-2008 unconstitutional. There existed a practice on the children of war, where we prohibited claims from the children of war for the future. And it was not quite clear what to do with the cases that were opened and suspended in the past. To keep to the same forward-looking logic. In that context, it sounds surprising. However, it's good that back then we spoke about monthly payments. However, there is a ruling of the European Court of Human Rights where our children of war came to that court. I think it was a decision from 2012 where the European Court of Human Rights decided that the rights were infringed in the period until the law was decided unconstitutional. And the decision included this quote: there were no legal expectations. So I have a question to you in particular. You have become a new source of certain knowledge from the Constitutional Court. So thank you for being here with us. My question is very simple. I could see the chambers now exhibit different types of practices. You called it, oh, I'm sorry, I don't know English very, erga omnes? Is that what you called it? This is when the courts decide a normative act as one that does not comply. Administrative courts, I mean, not a constitutional court. And from your presentation, I understood that whenever courts decide those normative acts, they become invalid from the moment of their adoption. I understood it that way. Oh, okay. That's good. So here is the situation. We have a normative act, a decree of the Cabinet of Ministers. It is deemed non-compliant by the court, and in its decision, the court says until from the 1st of January, it loses its effect. And when we speak about certain payments, when courts look into individual disputes, one chamber says back then it was in effect, it's good, we could require those payments. In other cases, because it's not compliant with the higher act, even in the period when it was in effect. Thank you. If I understand
Дивіться, як узгодити практику двох
Okay, how do we
палат, це не моя справа, звичайно. Я не знаю, яку вам дати пораду.
coordinate the
Але що
practice of two
стосується
different chambers? I don't
ситуації,
know
коли
what to
є
do about it.
рішення суду, яке
But let's
щось
take the
не
situation, a decision of the Constitutional
При
Court
этом
deciding
при
something
цьому,
is
звичайно, що
unconstitutional. And
виникає
of
питання
course,
застосування
there comes a
рішення до
question of
провадження, що тривають.
applying the
Другий момент,
decision to the
що
ongoing
Конституційний суд
proceeding.
має застосувати
And the
лише ті
second one, the
норми,
Constitutional
які
Court should only
визнані
apply
основними
norms
відносин, да?
that
Ну,
were
тобто,
in
кожна тлумачення
effect
може, по-перше,
in a
виступити по
period
кожному
of
пункту
disputable
законодавства.
relations.
В світлі того, що сказав
In the
представник
light
ситуацію
of
застосування
what the
цього закону може
Constitutional
вирішити
Court
у
said, the situation
Верховний, то відповідно може це зробити.
should be interpreted as conforming.
Наступне, якщо виникає
Number two,
ситуація, коли
if there is a situation
Конституційний суд
when
постановляє,
the Constitutional Court
щось неконституційне, скажімо так,
establishes that something is not constitutional, it could be about human rights, any type of norm is decided unconstitutional, it has a prospective effect. However, the norm is applied to the ongoing proceedings. Could we apply it retroactively? The position of the administrative court is correct. It does not have the retroactive effect. So how do we interpret the norm to be applied? There is a nuance here. It's a quite an abstract vision that I'm able to provide here, simply because every specific situation requires its own approach. The retroactive effect is tolerated. Our practice allows the retroactive effect if it improves the situation with the human rights. Article 58 prohibits that if it worsens. However, if it improves, and we have had a few decisions on that question, then we say there is no problem if it improves. There is retroactiveness, which is mandatory when there is a chaos in the law, and the legislator corrects it. That was a German decision from 76 or 78. It was on the agreement between Austria and Germany on legal aid. And it had a few criteria on the retroactiveness. And I think it could be applicable to our system as well. One more question to Микола. Alexander, thank you. But I believe after this answer, we need to organize a different separate meeting with you to discuss it all. Микоla, a question to you. We have a petitioner on the illegality of the decision. And how do we reinstate the violated law and to pay the money, for example? And the petitioner say this method does not apply. Do we reject this claim? Can the court select the method which is not accepted by the petitioner? The court obliges to pay the money, for example. But the claim was rejected because the method selected was wrong. Is this a violation of Article 6? Thank you. It's a great pleasure to be part of such an interesting discussion. Your question is very interesting. And I believe it should be decided in every individual situation. You cannot give an answer that would be relevant even for the administrative justice or globally anyway. When there are different ways to reinstate the violated right, the choice is by the claimant, the petitioner. They can select a civil or a criminal proceeding. For the European Court of Human Rights, it should be exhaustive so that at least one of the means of legal protection is exhausted. In the case that you just quoted, I will give you quite an abstract answer. I remember having at least one ongoing case with a very similar procedure, so I have to be very careful about that. And yet, when we speak about the formulation, so we speak about the material reimbursement as a result. So I think here the court has more space for maneuvering. If you compare that to a situation when there are many different ways. So the court has to decide here. I don't want to spend more time on this. But when we speak about the decision on unconstitutionality, I think it's quite normal. Ex nunc or ex tunc is decided by the Constitutional Court from the beginning or for the future. We have this wonderful Czech case. We have discussed it here in this Kuvat and others against Czech Republic. It was on the reduction of payments to the judges of the Supreme Court. So they brought that case to the Constitutional Court, and the Constitutional Court deemed it unconstitutional, but for the future, from the moment of that decision. And it did not judge on paying the indebted amount. They came to the European Court of Human Rights and they established the discretion for the national court. Please don't give away the microphone yet. We had a judge who said this, a serious infringement, a serious threat to the rights. What does it mean, serious? Is Francois still with us? Francois? No, I'm afraid a serious threat to rights. How do I understand that? Could you give an example to our judges? What is serious, what is not serious? Francois, have you heard the question? In your presentation, you said that one of the criteria for the court's referral to the State Council or the Constitutional Council, the justification by the court should include seriousness of the infringement, the serious. What is meant by this serious? Are there any criteria? How do we define this serious?
Yes, thank you for your question. As I said, when the application is in the hands of the judges of the first courts of first instance or court of appeal, the reasoning is that if there's a very slight, very little chance that the law might be considered contrary to the Constitution, then you have to refer to the Supreme Courts. And then you're right, when we're in front of the Supreme Courts, then it has to be serious. Well, maybe I could speak about a percentage. let's say that for courts of first instance, if there is at least 5% that the law is contrary to the Constitution, then they will refer to the Supreme Court. And then for the Supreme Courts, maybe the percentage is something like 50%. So if you look at it, when, let's say, my court, my Supreme Court, Council of State, decides to refer a case to the Constitutional Council, well, let's say that in 50% of the time, the Constitutional Council rules that the law was contrary to the Constitution, and 50% they say no. So that's about it. Sometimes what we do is that we think that the law is not contrary to the Constitution, but we think it's not up to us, the Supreme Court, to decide on it. So we think, for example, if the case is very sensitive, we have a law and saying that it's contrary to, it's compatible with the Constitution is very sensitive. Although we don't think it's very serious, we refer it to the Constitutional Court because it's better if the Constitutional Council decides on this topic.
Добре, дякую. Я перепрошую. У нас є ще запитання.
We still have questions. Larissa, we are going to continue with this discussion in a while. Mykola has to run. But I have a question to Mykola. Well, can you please be brief? Thank you. Thank you for the invitation and for your presentation. We understand that our topic is included in Article 7, but it's also in Article 11 of the Civil Code and in the Civil Procedural Code. So I think it was very interesting both for the civil and economic jurisdiction. However, the difference between Article 7 and other articles is that in Part 4 of Articles 11 and 10 that I mentioned is about the direct application of the Convention on Fundamental Rights and Freedoms. It's not included in Article 7, even though it mentions the international agreements. Our speakers often made parallels between the decisions of Constitutional Court and the European Court of Human Rights. If the convention is applied as direct effect, does it mean that the consequences will be the same? I believe the difference between the procedural codes in this aspect do not have a material difference, because the situation between the international agreements that should be applied as the national legislation. It does not mean it's unconstitutional, even though it is a serious red flag. There might be constitutional problems with that. But we have a convergence between constitutional law and the interpretation of Part 2 of the Constitutional Court and the case law of the European Court of Human Rights. And the Constitutional Court does not have an expensive case law yet. I'm very skeptical about it. However, I don't believe this automatically means it's unconstitutional. However, certain subjects might want to think about whether it's a question for the Constitutional Court. The Constitutional Court and its decisions have consequences for everyone and about everything. And individual cases, inter-parties, are the tasks of the judicial system. So I think this is the main difference. But thank you for the question. It's a pleasure to see you here.
A brief comment. Look, the Constitutional Court does not perform any convergence review to see whether it conforms with the convention or other international agreements. The conventional competence is your competence of the ordinary courts. Thank you, Larissa. I hope you will stay with us in the afternoon. We will be discussing equally important issues. Thank you very much, dear participants. Thank you for your patience. I will ask now our students to get ready, and I would also come down. We will now award our winners of the competition, and then we will have lunch. The only thing I said that as we're celebrating 20 years of the code, we have combined this event, and together with that, we had a competition for young people, for applicants for higher legal education, the competition on protection of constitutional rights of individuals and administrative proceedings. The competition committee assessed 41 student works that came to us from 23 universities. As a result of the ratings, 5 best authors of the essays have been identified. And to have, we can celebrate the winners of that competition. Mr. Smokovich is waiting, and to award the winners of the creative essay competition, I'm inviting here Diana Yasha, student of National University Hill Academy, who wrote about Chernobyl pensions. In our social chamber, please take that into account. At the intersection between constitutional guarantees and financial possibilities of the state. Thank you. That's a very important present to be awarded to the winners.
Так, дякуємо. Прошу, будь ласка. А ще?
Where Mr. Smokovich is one of the others. And that's a special coin issued by the National Bank of Ukraine to celebrate the 20th anniversary of the Code of Administrative Justice. These were the presents made by Mr. Smokovich. I'm inviting here Anastasia Andrushko, student of the Polytechnic University, wrote her essay about administrative jurisdiction in the cases of recruitment during the drafting process.
Науковий керівник, кандидат юридичних наук, доцент Малець Марта Романівна. Вітаємо.
Congratulations.
А науковий керівник тут? А підніміться, будь ласка, от науковий керівник, подивіться.
Do we have the professor of Anastasia Andrushko? Yes, we can see you. Daria Kotolchuk, student of the National Academy of Internal Affairs. Her essay is about implementation of the Constitution of Ukraine with its direct effect and administrative justice. Her supervisor is also here. Thank you for supporting the student.
Це дуже важливо. Дякуємо.
Thank you.
Запрошується Єлизавета Головко, студент.
Yelizaveta Holovko, student of the Trade and Economic University. The rule of law as the basis for confronting algorithmic bias, supervised by Katerina Dr. Zvereva.
Катерина Сергіївна немає, мабуть, так? О, Катерина Сергіївна,
Mrs. Zvereva is here as well. Congratulations to you.
Далі. Дипломом переможця відзначена Вікторія Вакулінська.
Victoria Vakulinska, student of the Ostroh Academy National University, who wrote an essay about direct effect of the Constitution and implementation of its provisions in administrative justice. It's an important subject. I understand that Ms. Vakulinska is not with us today. So we will definitely make sure that she receives her diploma, her words. Congratulations to the winners. Keep developing your scientific and professional potential and believe in yourselves, and we will help you with that. Thanks to everyone, all the participants of the competition, and to the court for this initiative that inspires future legal professionals of Ukraine. Now, I invite all the participants to take a family picture, and then we will have a lunch break.
Михайло Іванович, якщо можна, я зроблю коротенький вступ, трішки присядете, будь ласка, да? І я так, ну ми будемо починати. Ми готові? Готові? Чудово. Шановні колеги, ми продовжуємо нашу роботу.
We continue our work. Could you please get actively engaged? You're kindly invited to take your seats if you're not in the room yet.
Так. У нас є і онлайн-слухачі, які також нас
We have online participants that are waiting for us to resume our work, so we continue. The second session is called the plenary session of the Supreme Court as the institution of preliminary control, potential conflict or cooperation. The decision on whether to submit a motion to the Constitutional Court of Ukraine regarding constitutionality of the law or any other legal act that is within the jurisdiction of the Constitutional Court of Ukraine is considered by the plenary session of the Supreme Court. And the latter can vote either for or against this submission. That means that the court of any level within the judicial system cannot directly go to the Constitutional Court, but only through the plenary session of the Supreme Court, which acts as a kind of a filter in the decision-making process as to the potential application of the Constitutional Court to the Supreme Court. And we are not the only ones. As you've heard, there are some other European countries regarding that. If plenary session of the Supreme Court refuses to accept the submission, dismisses it, the question is, can we assume that the Supreme Court replaces the constitutional jurisdiction body, presuming the conformity or consistency of a law or other legal acts with the Constitution. Then there are some other questions arising from here. What are the risks of unfounded decisions by the courts of lower instance that refuse to apply the law or other legal acts in favor of the fundamental law? And the plenary session of the Supreme Court refused to such court to appeal to the Constitutional Court. For example, if the court of the first instance established a conflict between the law, other legal act, and the Constitution of Ukraine, and makes the decision that they should go to the Supreme Court to resolve this issue regarding the constitutionality of this act, and if the court revokes it, then the question is whether the decision to go to the plenary session of the Supreme Court should be changed if the appeal was satisfied. And then the question is it the right or the duty of the court to go to the Constitutional Court of Ukraine if the court decides that the law or other legal act is contrary to the Constitution of Ukraine, since the decision of the higher court as part of the judicial review can be revoked. So that's the questions that we are going to try to find the answers to. And let me give the floor to our main speaker of Session 2, Mihailo Smukovich, President of the Administrative Cassation Court within the Supreme Court of Ukraine, a doctor of law. Can you help us to find answers to these questions? Thank you. Thank you. I'll try to help you, but I needed to arrange all the ideas that I have. Dear participants, ladies and gentlemen, I am happy to welcome you at Session 2, the plenary session of the Supreme Court as the institution of preliminary control, potential conflict or cooperation. Constitutional review or constitutional control is one of the key elements of the doctrine of the rule of law that provides for compliance with the Constitution in legal systems and guarantees the direct effect of the constitutional norms. At the same time, administrative justice acts as practical mechanism of application of this principle, because it is through administrative courts we exercise control over the work of entities. So both constitutional control and administrative justice form the system of the guarantee of the constitutionality of acts, and they interact in the following forms: application by the administrative courts of the constitutional norms as the sources of law, initiating the issue regarding constitutionality of laws and other legal acts in the course of consideration, the use of the constitutional court decisions as the mandatory guidance for administrative case law, the participation of the plenary sessions in constitutional submissions as the form of the preliminary control. This combination serves as the basis to shape the uniform system of application of the law, where constitutional standards are an integral part of constitutional jurisprudence. Therefore, Article 7 of the Administrative Code is of primary importance that establishes boundaries for the administrative courts to apply legal acts that could be contrary to the Constitution. The plenary session of the Supreme Court is one of the key elements of the institutional mechanism to provide for the uniformity of case law and shaping the fundamentals of the judiciary per se. However, the plenary session itself should be differently interpreted when we see the transformation of the judiciary, especially when it comes to administrative jurisprudence, that is the direct interaction of court and public governance. In 2016, following the adoption of the law on judiciary and status of judges, the functionalities of plenary session were subject to significant updating. The lawmaking role of the plenary session was revoked in the form of official explanation, so-called soft law. Previously, they were mandatory, and then they became advisory for the courts of lower instance. At this stage, plenary session does not issue this type of explanatory notes for a simple reason that's not in line with European standards, since this gives rise to the influence for the expression of will when considering disputes, and it just consolidates the case law and pays attention to the main trends of application of the law. But the plenary session started operational in 2015, but recently they didn't provide any kind of guidance. Methodological activity became the focus of its work. The decisions of the plenary session as to the application of the law it doesn't have the features of regulation, which is in line with European standards. The principle of independence of the court and the principle of division of powers. As of today, the plenary session in the system of the institutional architecture of judiciary decides on the applications to the Supreme Court as to constitutionality of legal acts. Therefore, the role of the plenary session in the architecture of judiciary is of organizational and coordinating nature. The previous, or rather, tentative control could give rise to conflicts and contradictions, and it can also recommend the ways of resolving them, and therefore it reinforces the role of the court. If you see the plenary session as the institution of preliminary control, we have to understand that that's in formalization of this institution within the judiciary. And given the administrative judiciary, this dialogue is of special importance because it is here where the Supreme Court deals with public governance and decisions of public authorities and rights of citizens. So there is room for improvement here to balance the principles of independence of court and uniformity of case law. This understanding of the plenary session and its role is in line with modern trends of European administrative jurisdiction based on the principle of openness and predictability of interpretation of the work of court. Under modern conditions, the plenary sessions became more and more analytical, especially when it comes to the questions of legal relations that are subject of administrative jurisdiction. When we talk about the preliminary control and constitutionality issues, then we have to understand this not as a control, but rather as a preventive assessment of application of the law, especially when there is an issue of potential conflict of the act in question and the Constitution. Though under the law, plenary session is entitled to submit constitutional submissions, not only on the basis of the cases that have already been considered, but as the entity that is entitled to submit these petitions. So in other words, the judiciary can initiate eliminating potential discrepancy of the act and the Constitution prior to this conflict having a negative effect on the case law. And the Supreme Court had a case when the plenary session at the beginning of the year analyzed some laws, especially the budget for the country for the upcoming year. And at this plenary session, and without respective case law courts decisions, it could point out to the articles of the budget that are not in line with the Constitution and therefore could go to the Constitutional Court to seek recognition of these provisions as unconstitutional, and then they lost effect as a consequence. At the moment, plenary session of the Supreme Court continues this practice, though there are some concerns that we hear from some politicians that are expressed in public, but if we had some motions that could be submitted by the plenary session, like the ones that I quoted, in particular, if it were about the public budget, then it would be really very helpful. It would be very helpful to protect the rights of the individuals, but the practice that existed before the Supreme Court was established have not been resumed by the plenary session of the Supreme Court. And when you talk about the constitutional submissions or petitions, then as of today, most of the constitutional petitions deal with administrative jurisprudence, and they are initiated by the judges of the administrative courts. And initiative of the plenary session regarding constitutional petitions is the mechanism of responding by the judiciary to legal uncertainty or potential conflicts that are reflected in the court rulings or decisions, especially that's typical of tax cases, social cases, and conscription in our country. So what are the advantages for the administrative case law if these petitions are there? So that secures uniformity of the case law, that improves the quality of lawmaking and strengthens trust to judiciary, because the initiative of the Supreme Court presents the court as an active defender of constitutional rights. The courts, the judges often initiate constitutional petitions and requests to the plenary session of the Supreme Court. Plenary session of the Supreme Court as institution of preliminary control performs a very important constitutional function. It guarantees its uniformity and unity, and in terms of the application of the law. If the decision to submit constitutional petition regarding constitutionality of laws and legal acts and official interpretation of the Constitution of Ukraine is the form of the preliminary constitutional control, and it is based on the conclusions made from the case law of administrative courts. So given all this, the plenary session of the Supreme Court is an institutional partner of the Constitutional Court of Ukraine in providing for the constitutional legal order. And then let's take a look at Article 7 of the Administrative Code of Ukraine, and it says that if the court found that law or any other legal act is not in line with the Constitution, the court then cannot find it unconstitutional itself, but is to apply constitutional norm as the norm of direct effect and decide the dispute. Let me just say on this that it's not easy for the administrative courts because the issues that were raised by the moderator, and that's the instances when the courts do make these decisions, and even in cases when cassation courts upheld these decisions, then if it is a constitutional petition that is submitted to the plenary session of the Supreme Court, we see the instances when the plenary session of the Supreme Court does not go to the Constitutional Court with this petition because it lacks votes in its support. So we have therefore to look at the legislation to govern this issue.
Because if the cassation court supports this position regarding unconstitutionality, in that case, I believe the plenum of the Supreme Court must be so. Based on these grounds of unconstitutionality, it cannot reject the appeal to the Constitutional Court. However, where the decision of courts are cancelled, withdrawn by higher instances, where higher instance courts do not support this vision of non-compliance with the Constitution, in that case, it does not oblige the plenum of the Supreme Court to reject the motion, but it is then their discretion. Then they make this individual decision. Each court judge, they make their discretional decision whether there should be the motion to the Constitutional Court. As Mr. Vadyanikov mentioned, the plenum cannot replace the Constitutional Court. Of course, that's true. However, the vision, the authority of the plenum, if they are convinced of non-constitutionality, well, there is no duty to go to the Constitutional Court. And when they analyze our constitutional motions, we see that there are a lot of refusals to initiate constitutional provisions, and that's another proof of how high the professional level is. I mean, so of course, if the judges see that a law is in line with the Constitution, we should not oblige them to go to the Constitutional Court if that is stipulated by the first or second instance court. Thus, the Supreme Court, as the highest judicial authority, plays a key role in providing for coordination among the jurisdictions, and the plenum is the institutional platform for analytical assessment of the state of law, implementation, generalization of the practice, and initiating motions to the Constitutional Court. And here, let me also mention that in the work of the plenum, there are the cases where the same motion, the same rationale are used, but the constitutional motions submitted for the plenum session like a year ago, they were resolved in different ways. In the first case, this motion was not accepted by so the plenum did not make the decision to refer it to the Constitutional Court, while in the second case, there were only 2 votes against that, and 1 vote was actually in order to expand the scope of that motion, while the second vote was submitted for political or moral reasons, not so much for legal reasons. Again, this is the situation that we witness now, and we need to take the current context into account, but I believe that in that situation they were the same, the circumstances. So the work of the plenum, the regulation, the independence of the plenum, of the judges who are members of the plenum, all of that is quite basically a challenge. Even though we do have some elaborations, we have some regulations, but the recent plenum session proved that if a higher instance court cancels decisions of lower instance courts, that may be seen as grounds to go to the Constitutional Court and the plenum cancel those. So even though the Constitutional Court expressed their position regarding constitutionality of certain provisions. So, I mean, dear participants, dear judges, we still have lots of issues there, and the settlement of that issue won't be perfect because every judge is independent and they have their own perspective and standpoint on various issues. So if this, I believe, if it is about decisions made against individuals, individuals have another tool of protection. This is constitutional appeal, and members of the plenum must take into account that if they reject that, while if under the constitutional complaint the provisions will be deemed unconstitutional, that will be like feedback of the public on quality of work of the plenum, on the level of judges in the Constitutional Court, in the Supreme Court, sorry. So we need to take that into account. And now my conclusions. Constitutional control and administrative justice, these are two linked components of this single system to protect rights and freedoms of citizens in Ukraine. Their interaction implements the principle of the rule of constitution, and it provides for predictability of actions of the state. The plenum of the Supreme Court acts as an analytical and coordination center, and thus it can be an institution of preliminary control. And I believe that there are not just formal reasons to think so. I mean, it's not only about formal aspects of the motion, but as Mr. Vodyakov said, that plenum may replace the Constitutional Court. No, it does not, but they may have a different opinion. So this is about the link between the institutional and constitutional intentions of justice, but further implementation requires clear procedures that will guarantee comprehensive constitutional dialogue among courts of various jurisdictions. Institutional interaction between constitutional control and administrative justice, that's not only about organizing the judicial system, that's also about preconditions for the modern European model of the state that is ruled by law. We are working in this direction in order to regulate that, and I believe that even the opinion of a first instance judge, if they express doubt about constitutionality of a certain provision, that opinion must be heard. And if it is cancelled by the Court of Appeal or the Constitutional Court, that's one thing, but it needs to be heard by the plenum. Otherwise, there is the Institute of Constitutional Complaints Appeal. So that's it from me, I guess. And I believe that Mykola will add to what I have said. He is an ex-judge of the Constitutional Court of Ukraine, and we will continue discussing this aspect. Thank you. Ms. Banic has joined us online. Ms. Slavica. Hello.
Hi. Hello, everybody.
So, hello, and Ms. Banic has participated in all of our international workshops, I guess each of them, can you believe me? So, maybe Ms. Banic is the greatest expert of our legal issues, the issues that we face in the aspect of application of Article 7 in particular. Thus, we look forward to hearing about advantages or disadvantages, pros and cons of our system versus the situation in your country, the preliminary judicial control in the context of the jurisdictional delineation. So the floor is yours. You're welcome.
Thank you very much, dear participants and esteemed colleagues. It's really great to see you all again. Judge Miroslava, and also greetings for the President of the Supreme Court, Administrative Court Cassation. I'm happy to see you again, and I'm also thankful for Council of Europe to have made this meeting possible. I have made the PowerPoint, and I tried best of myself to put it in Ukrainian. So please, if you find these Google English Croatian translations, Ukrainian translations incorrect, my apologies from the start. I gave my best, but probably subsequently it can be changed. So I will start my. Do you see all of this? Do you see behind? Is this?
Just a second. Let us check.
Just a moment.
We're checking. No, we don't see.
Just a moment. Just a moment. There it is. Okay. Do you see it now? There we go.
Зараз, секундочку, має з'явитися. Хвильку, будь ласка. О, дякуємо. Все є, чудово.
Yeah, now we have it. Thank you.
Now you have it. Okay. So, first of all, I will start from the fact that both acts on constitutional courts of our countries foresee the Supreme Court, the highest judicial body in both countries, to be the authorized body to file a constitutional petition, which is the case in Ukraine, or a request, which is the case in Croatia, for the review of compliance of laws and other legal acts with the Constitution. However, if you see, while in Ukrainian, this right has no limits, it's just a general provision. In Croatia, the Supreme Court or any other court are limited to the issue of constitutionality and legality that has arisen in proceedings conducted before the particular court. So for your information, just before to know, we in Croatia have, just a moment. We in Croatia defer request and motion, proposal, because proposal can be submitted by each citizen or legal person in Croatia to initiate constitutional review, while the request is something like constitutional petition in Ukraine. Only certain authorized bodies, state bodies, can submit requests for the review of laws and other regulations. So this is a slight notion, you know, that we defer this thing. While this constitutional court has to act upon the request of the state bodies, it does not have to obligatory to act upon the proposals of the citizens and other legal persons. So it can reject the initiation. So in the context of the meeting today, as you can see, we speak that the Ukrainian law on constitutional court, as I could see, does not actually have the norms on exceptional legality like it is the case in Croatia. We have this issue regulated by the Constitutional Act on Constitutional Court, and our Constitutional Act on Constitutional Court foresees two situations. So the first one, if the court, so it means by any court in the Republic of Croatia, determines that the law is not in accordance with the Constitution, it shall stop the proceedings and present this request to the Constitutional Court for the review of the law or some of its provisions. However, paragraph 2, in the case of other regulations, for example, ministerial decrees or governmental decisions, if the court determines that that kind of regulation is to be applied, but considers that it is not in accordance with the Constitution, with the law, it shall directly apply the law to that specific case, and then it will present a request to the Constitutional Court to review the constitutionality and legality of that disputed regulation. So in both cases, as you can see, Constitutional Court, when receives such requests from the courts, it is obliged to inform the Supreme Court of the Republic of Croatia about it. So what does this mean in the practice? The court, so it can be also administrative court or the civil court, stops the proceedings, files the requests, and waits for the decision of the court. So there is no action in the proceedings. However, in the case of the disputed other regulation, the court does not stop the proceedings, but it directly applies the law, and at the same time, it files the request for the review. So in that regard, the individual case is resolved on the base, when the case is resolved on the basis of the law, but not on the other regulation that is disputed, the consequences in the latter situation is the following. As you can see, the Article 60 of the Constitutional Act says, if the final judgment is made on the basis of the law, because of disputed constitutionality and legality of other regulation, but the Constitutional Court found that this other regulation was not unconstitutional or illegal, so that the unconstitutionality does not exist, everyone whose right has been violated may require a change of the final judgment of the court during the term of 1 year from the publication of the Constitutional Court. I also immediately must tell you that Constitutional Court of the Republic of Croatia did not have a lot of experience with the application of this institute, because the courts, including Supreme Court, are hesitating to file such requests. I personally attribute this to a formalistic approach of Croatian courts to this institute. However, in 2013, we had a very interesting issue that in the proceeding before the commercial court, the judge ruled to stop the proceeding because he considered that the law to be applied was not in accordance with the Constitution, which is why he submitted a request to the Constitutional Court. However, if I return back, to see who can file a request, it says the Supreme Court or any other court. So it doesn't say a judge of the court. So before the Constitutional Court, we had really a large discussion. At that time, I was at the court. We had a large discussion whether an individual judge may file the request, or it has to be the court where the proceedings is held. So the Constitutional Court concluded that a judge, as a personal bearer of judicial functions in the court, is excluded from the authorized body to submit a request, and this should be done by the court, which conducts the proceedings. So this, however, does not mean that the judge cannot raise a proposal for the assessment of the Constitution. But because of the consequences, you know, it's different. When a judge proposes review, the Constitutional Court is not obliged actually to act upon it. But if the court sends a request, it is obliged to act. So what was also interesting that the Constitutional Court in this decision emphasized certain rules for exception of legality. First of all, it said that only requests of the court and not proposal of a judge suspend the concrete judicial proceedings. Then the request must indicate in connection with which specific proceedings before the court the issue of constitutionality of certain law or individual provision has arisen. The request allows for the review only of those provisions that are to be applied in specific court case and not any provision of the law. And finally, objection of unconstitutionality of legal provision require justification in relation to the specific case to which they are to be applied. So actually, we sent a message for the courts that they really have to elaborate in connection to which case it has to be connected, the issue of constitutionality of the law, also in connection of which judicial proceedings, etc. But I must tell you that this strict approach that only the court may submit to a request for the Constitutional Court has been abounded silently, which means actually that in 2016, it was a ministerial decree where the judge submitted a request for review, constitutional review, and the Constitutional Court accepted it as a request of the court, not a proposal of a judge. So, what we had, what appeared as another problem in an application in connection with the law on administrative disputes, which could be the Codex on Administrative Proceedings in Ukraine. The application of exception of legality came into question actually what it was meant by other regulations. The issue appeared when we actually introduced a new law in 2010 and which was enforced in 2012, which actually gave the administrative courts of the first degree and the high administrative court. We introduced also the full jurisdictions dispute, and we introduced the competence of the high administrative court to evaluate the legality of general acts. So the problem was actually how to demarcate, how to actually make division between other regulations and general acts. And from this decision of the Constitutional Court from 2012, just in order to be rather fast in my presentation, actually the Constitutional Court made demarcation on the basis of the authority that enacts general acts and authority that enacts other regulation, which means that the Constitutional Court is entitled for the constitutional review of the other regulation of the state bodies, while general acts of local government, of the public bodies entitled to decree certain areas, they are actually given the power, they are defined as general acts, and they entered the competence of the High Administrative Court of the Republic of Croatia. So how was this determination, this demarcation of jurisdiction to assess the constitutionality of other regulations and general acts reflected in application of the Article 37 of the Constitutional Law on Constitutional Court? So, The High Administrative Court has the right only to review whether General Act, for example, a local government act on communal order, complies with the law on which it is based or with some other legal provision. Because since the compliance of the law with the Constitution is a genuine competence of the Constitutional Court, so it means that in the course of the proceeding, the High Administrative Court, when evaluating legality of General Act, cannot evaluate the law at the same time. And it has the right to suspend the application of the law and submit requests to the Constitutional Court in order to review whether the law on which basis the General Act is enacted was constitutional or not. So, after this brief introduction of exception of legality in Croatia, I tried actually to see how with respect to the application of the Article 6, how does it work in Croatia and in Ukraine? So as you can see, in both countries, the Supreme Court is the authorized initiator of the assessment of constitutionality. However, in Croatia, any other court may do this. So in the context of the Article 7 of the Code of the Administrative Proceedings, it seems that actually the Administrative Court directly applies the Constitution if it considers that a law or other regulatory act is unconstitutional, and then appeals to the Supreme Court for the decision of submission. While in Croatia, submission of a request terminates any jurisdiction of the Supreme Court to assess the merits of the case, or the court is only entitled to apply the respective law. In Ukraine, the court, but the Administrative Court, applies Constitution as substantive law. So further on, when appeal comes to the Supreme Court, this is my view, and I don't know whether I really caught the sense of the Article 7 in all of these translations is, if the Supreme Court rejects to accept the appeal and submits constitutional petition, the decision of the court in proceedings actually is based on a direct application of the Constitution, and it shall be maintained and will produce legal effects on the basis of the Constitution directly, not of ordinary legislation. However, if Supreme Court accepts the court's appeal and submits a constitutional petition, it shall place the direct application of the Constitution in the individual case under the supervision of the Constitutional Court and allow Constitutional Court to decide whether a direct application of Constitution was constitutional or not. So, but we come here to the issue about how the Supreme Court will act upon the appeal, whether the appeal, what about if the appeal is adopted and how the Supreme Court will act. This is something that I just could not resolve. But finally, just another final remark is, for me, it seems actually when the court does not apply the law, but applies the Constitution, in a way, de facto, actually, it decides on the constitutional complaint according to the constitutional law on constitutional court. Because as I could see, actually, everybody who thinks that by final judgment, the law actually violates the right can apply for the constitutional complaint. So in this case, actually, we have a kind of shortened way for the Constitutional Court, because it is an ordinary, it is the Administrative Court that actually, by non-application of the law, in a way decides on constitutional complaint. So by my opinion, the action of the Supreme Court, if it accepts the appeal and files the constitutional complaint, of course, that such move is vital in protection of the constitutional and Ukrainian legal order, because it enables all courts to stay within their constitutionally allocated powers. So otherwise, rejection raises the issue actually that we have a kind of too many courts with constitutional powers at stake. Thank you very much for your attention. I hope I was clear enough, but I'm at disposal for your questions with regard to anything that was said here. Thank you.
Thank you very much indeed. Your presentation was a very good continuation of those questions that were raised by the President before you. That these were the scenes regarding the preliminary control, and preliminary control covers the issue of independence in practical matters in every specific case. And on your part, you showed a different angle that looks like that, to rephrase it. Isn't there too much freedom for the courts, let me put it this way, or how limited or unlimited courts are to make this type of decisions? I mean, the decisions regarding constitutionality. Let's move on. Thanks a lot. I think we'll have a discussion at a later stage, and if possible, could you please stay with us? And then, if you look at the agenda, we see that the next to speak is Virgilijus Valančius, Senior International Expert Support to EU Integration Process in Justice as Sector Component Lead, EU Project Private Justice, Doctor of Law. So my question to you then, is there any synergy with the European institutions that you see in Ukraine? How we can harmonize the standards for constitutional justice with the practice that we see in the EU? Thank you. Thank you, Miroslava. Can you hear me? Yes, we can. It seems to me that the issues at hand today are very interesting. There could be different arguments in support of this or the other position, and you've heard different positions expressed today. Let me discuss this issue through the lens of EU law and jurisprudence of the Court of Justice in particular. As we know, judiciary architecture of the EU is structured in a way that without cooperation of and with the national courts of member states and EU court that is based in Luxembourg, it would be next to impossible to secure consistency and uniformity of the EU jurisprudence. Several member states make some attempts, in inverted commas, to govern national courts in their shaping prejudicial request to the Court of Justice. By the way, since October 2024, the General Court is entitled to issue prejudicial decisions. So there are several ideas as to the parallels with the Court of the EU that could be useful to you. For lack of time, I will cover only two cases. ES, Hungarian case, and RS, Romanian case. Hungarian judiciary faced discussions as to prejudicial request under Article 267 of the Treaty on the EU functioning at the stage of request, and that's very important. There are two stages. When you submit the request, that's question stage, when you go to the court, and the second stage when you receive prejudicial decision, and then you have to implement it. Autonomy of the judge that submits request regarding prejudicial request. That's the decision of November 23, 2021. And by the way, in Hungary, there is a contradictory mechanism where at the stage after prejudicial decision there could be questions raised, but that's not something that we are discussing today. Some facts in the case. When Hungarian judge, it was a criminal case, received the materials of the case, he noticed that the person of Turkish origin, Swedish residency, was interviewed in the presence of a Turkish interpreter, and the judge had to issue decision in absentia because the accused was released at the stage of indictment, and he left Hungary and he couldn't be found. So there was no information. That's very important. How the interpreter was selected, how competence of the interpreter was verified, and whether the interpreter and this person, ES, could understand each other. These were really very important questions. The judge and the judge of the first instance was the judge of the city of Pesta, had a question whether Hungarian legislation and case law of Hungary were compatible with some of the directives. And the directive of question was directive of 2010, the other directive was the directive of 2012, and whether the EU law gives rise to the fact that in case of non-compatibility, the criminal case cannot be continued in absentia. So, therefore, the judge of the first instance referred this question to the Court of Justice, and by the way, he raised several other questions that deal with the Hungarian judiciary, the governance and the procedures. It was in July 2019 when he referred these questions to the court. In November 2019, the judge added to the initial request with some other elements, and that's important to note too. So the complemented part stated that Prosecutor General of Hungary, following his initial request, submitted an appeal in the interest of law to the Supreme Court on the basis of the Criminal Procedure Code that was aimed against the request regarding prejudicial decision. The additional request also states that in September, the initial request was in July, and then there was an appeal, and in September, Kuria, that's the name of the Hungarian court, found the initial request regarding prejudicial request unlawful on the ground that the question raised wherein was not related to the main case. Under Hungarian system, the judges are to abide by the Supreme Court decisions regarding the continuity and certainty of jurisprudence. And if the judge fails to do so, he could face the risk to be brought to disciplinary liability. Nobody would care about that if Hungary were not an EU member state where the rules of the EU prevail and act as the primary rules, and they prevail over national legislation. This additional request, prejudicial request, was submitted by the Hungarian judge of the first instance, and at a later stage it was blocked by the Supreme Court, and this was known to Luxembourg judges. The Court of Justice stated that Article 267, the Treaty on the functioning of the EU, should be interpreted in the manner that prevents the Supreme Court of the member state to announce after the appeal of the case, as it was in Hungary, that a prejudicial request that was submitted by the judge or anybody else, it doesn't really matter, is unlawful. And it doesn't matter whether it was the first instance or the Court of Appeal judge that submitted this request. So the primacy, the supremacy of the EU law requires that the court of the lower instance ignored, that's what the Court of Justice said, this decision of the Supreme Court. They were covering other issues as well, but it's not related to our discussion today. So we can summarize and say that the Court of Justice said that it is only European Court of Justice that is entitled to decide whether the question raised by the national judges as to the interpretation of the law of EU are relevant to the case, that national the judges are deciding.
Цим рішенням продовжує захищати національних суддів.
I believe that with this decision, they continued protecting individual national judges to make sure that they make their decisions in an independent and free way. And this started with the case of Portuguese judges and then the court in Malta, lots of other cases. No internal administrative or institutional filters are required. And here I'm speaking about the judicial architecture of the European Union. Another case is a Romanian case. This is also about the possibility for a national judge to decide whether the national legislation and case law are in compliance with the practice of the EU. And there it was more delicate since it was about the practice of the National Constitutional Court. And here in the audience today, we have representatives of the Constitutional Courts, and they now that there are several cases where the conflicts may arise between several constitutional courts of member states and the court in Luxembourg. In that case, RS case, the decision was made on the 22nd of February 2022, and there the Court of Justice confirmed the duty of national courts to fully apply provisions of the law of the European Union with direct effect, even without applying national rules of practice, which goes counter to EU legislation. And their conclusion was the following: constitutional courts cannot build walls between the Court of Justice and national judges regarding the value of the rule of law as indicated in Article 2 of the European Treaty. The Romanian court that submitted the request in that specific case, RS case, asked whether we should interpret the second item of Article 19 of the European Treaty together with Article 2 of the European Treaty and also Article 47 of the European Treaty Charter in such a way that goes counter to national practices, that impedes national practices, according to which courts of member states do not have the jurisdiction to consider compliance with of the national legislation with European framework, where the Constitutional Court of the member state deems it compliant with the national provisions that requires compliance with EU legislative provisions. So it was confirmed that that's not possible, that that goes counter to the respective agreements. And I remember that there was one case in my country, in Lithuania as well, where the Constitutional Court stated that one of the laws was in line with the Lithuanian constitution, but further on, when this case was considered by the Court of Justice, they deemed that unfortunately several articles of that law of Lithuania were not in line with the EU legislation. So let me summarize in this way. Both the EU and ES and RS decisions in those cases, as well as in other cases, prove that primacy or supremacy, the rule of law in the EU always prevails, and any attempts of national authorities via legislative amendments or via the practice, the case law to limit those are considered by the Court of Justice such that they're not in line with the EU legislation. The Court of Justice also believes that all judges of the EU, there are about 80,000 judges in the EU, that all of them have the right to freely address the Luxembourg court with the clarification questions where it is about the EU law. And going back to the Ukrainian context, we know that Ukraine has 4 cassation courts, the large chamber, the plenum, and also there is the respective experience. All of us know that
відносин передаються на розгляд
where
в інші юрисдикції.
the cases that have this public element, they are transferred to other jurisdictions. So sometimes administrative cases are heard not by administrative courts, but by other courts. In Ukraine as well, there is the Institute of individual constitutional motion since 2016. So it is possible for an individual to go to the Constitutional Court with an individual motion. And there are no filters, intermediary filters. The Constitutional Court, that's the only body. And here, in this cases, this is the body that is authorized to confirm constitutionality of legal acts. And also there is a certain link where there is a link with the specific case that needs to be addressed by the judge of general jurisdiction. And also, this is how it is done by the Court of Justice or the General Court, where it is necessary to resolve whether this is a so-called fictitious motion or the judge that goes to the Court of Justice really intends to get the answer, the response that is required to address, to resolve a case on their table. Thus, similar to the Luxembourg Court, I believe the court can make the decision whether the reference to it is applicable or not. I also agree with Mr. Vadyanikov that this practice is in line, I believe, with the case law of the Court of Justice of the European Court. Thank you so much. Thank you. Now we have one more speaker, Mr. Mykola Melnik, Judge of the Constitutional Court of Ukraine, retired Doctor of Law. So, to what extent the Constitutional Court takes into account the concept of the living law? So now we discussed this aspect today, and you heard that other codes have similar provisions, but to what extent the Constitutional Court, when considering and interpreting disputes regarding constitutionality, takes into account this living life law that may arise in the cases that are in particular heard by administrative cases. На микрофон. The microphone is not working. So thank you for the invitation to participate in this event. It's been a while. I'm sorry if I say something out of place. So answering your question now, whether the Constitutional Court takes into account the live practice of administrative courts, well, it depends. Based on my experience, I can say that there have been constitutional provisions where we would go deep into decisions of courts, not those were not only constitutional complaints, but also motions, and the judicial practice was defining for the decision of the Constitutional Court. So in the constitutional motion, of course, you have to rely on analysis of the case law, both on this case and similar cases. So a lot of things depend on the reporting judge of the prokurator. So, dear colleagues, I would like to focus on the question or issue of the plenum, but first I would like to say a couple of words about those aspects that were covered during the first session. And actually, at today's seminar, we can ask this question in this way: whether the administrative court crosses the roads with the constitutional court. No, nobody can do that because we know about the mandate, the role and the mission in the judicial system and the system of public authorities. Constitutional court may stumble, though, and it has happened. We remember the decision of 2003, 1+1 on the third term for Leonid Kuchma, where the Constitutional Court said that 1+1 is 1 equals 1. And also in 2010, the Constitutional Court basically amended the Constitution, and that was contributed to the intentions of President Yanukovych. The decision of 2016, when the Constitutional Court interpreted the phrase of the Constitution of Ukraine at the session of the Verkhovna Rada, where they said that next session is any session that takes place later in time. That was a draft law on amending the Constitution and the special status for Donetsk, Luhansk, so-called People's Republic, and it needed to be extended, and now it is basically in limbo because of that decision of the Constitutional Court that created the conditions for the illegitimate amendments to the Constitution, undermined this system. So whether administrative and constitutional courts compete, yes, on the one hand, we have discussed that already. On the other hand, this competition should not arise, even though definition of constitutionality of a law or a legal act, this is the competition of the both courts. However, we need to keep in mind that there are different grounds, different procedures, and different consequences. And the administrative court, where they analyze the issues regarding a certain act, it is conducted based on provisions of this legal act, and in this way constitutionality is confirmed. The Constitutional Court explores the legal essence of the respective act and interprets that based on its understanding of certain provisions of the Constitution. And we had this discussion with Mikhailo, and basically we can say that the administrative court prevails to some extent because in the context of Article 7 of the Code of Administrative Justice, every judge of the administrative court is a sort of a constitutional court defining whether certain provisions are constitutional or not. But if the constitutional court analyzes the application of certain act for in the constitutional terms, well, the administrative court may deem a certain act as unconstitutional, but they cannot do anything about this act. But for ignoring or circumventing or applying a higher act like constitution, while the another administrative court may make another decision and apply the provision that the other administrative court had not liked. As a result of deeming unconstitutional of a certain act, it just disappears from the legal system, so it is non-existent. It is void legally if it is the decision of the Constitutional Court. Every judge implements the rule of law and they work for the joint result, and this is how it must be, because functional distribution of public authorities into these three branches implies that there is delineation of powers among various branches, and they must independently perform their functions in accordance with the Constitution and the laws. That was the decision of the Constitutional Court of 2016. That was when I was the a judge of the Constitutional Court. We had long discussions on that statement, and this is what we see there. And our German colleague that the President Broker said that the constitutional and administrative courts must work together. They must not compete. And undoubtedly, if we speak about competition and about the authority in the part of recognizing, deeming an act unconstitutional, the ideal scenario would be where all issues of constitutionality of legal acts were resolved by the Constitutional Court. The Administrative Court would then simply apply its decisions and legal position. But in our reality, it's not the case. First, as mentioned by Mr. Raghvenda, the current legislation of Ukraine contains a huge number of obviously unconstitutional provisions. Secondly, that basically in lawmaking, we see substantial legal nihilism, where even direct provisions of the Constitution are ignored. It was mentioned that the Constitutional Court deems a law unconstitutional, but the Verkhovna Rada may ignore that and re-adopt it because there is the political need or economic need. But, well, this is what happening. And thirdly, these situations, activities of the Constitutional Court contribute to these situations. For various reasons, they often avoid addressing important constitutional and legal issues, and they refuse or close provisions, or they may postpone it. And I'm speaking about what I know. This may happen, and this is a phenomenon that may happen for various reasons.
Low productivity of the Constitutional Court is exacerbated by the quality of its decision. That's when the decision of the Constitutional Court has constitutional provisions, not formal provisions of the Constitution, but rather their understanding of the Constitution, explaining the constitutional provisions and expressing its personal position and substantiating its decision. So basically, it should be continuation of the Constitution. So the decision of the Constitutional Court is a kind of a follow-up of the continuation of the Constitution. And very often that's what is missing in Constitutional Court decisions. The Constitutional Court is to expand its understanding of the Constitution through providing interpretation of the constitutional provisions, and interpretation not by the submissions or requests, but in every case, in every case I was the judge in, the Constitutional Court is to provide understanding of the Constitution and substantiate why the Constitutional Court is referring to this particular article of the Constitution. Then it would be better understood how the Constitution is applied. Just reference to the article of the Constitution is not enough. What should be there is interpretation of this article. Then the Constitutional Court will have less issues and less cases regarding constitutionality of legal acts and application. Very often, a lack of plausible arguments are replaced by the references to Venice Commission or European Court of Human Rights decisions that you see in the decisions of the Constitutional Court. But it's different. The Constitutional Court examines the legal act in hand, not regarding its compliance with the Convention on Human Rights, but regarding its constitutionality. Mykola Gnatovsky, judge of the European Court of Human Rights, has said that national constitutions, and the same for Ukraine, sometimes equal or even a broader when it comes to protection of human rights. Our constitution was recognized as one of the best in the world. So when we hear the question what the Constitutional Court should start with, then it should be Constitution, and the interpretation of the Constitution should be the first, and then we should look at the application of other important elements, including European Court judgments. It seems to me that there is some kind of a trend of referring to the European Court judgments. It's a kind of fashionable. As soon as there is a reference to the European Court judgment or Venice Commission, then that proves that you are in line with European trends. But it's not always the case. You cannot compensate constitutionality with that. There is another trend when it comes to local and appeal courts. If it is a dispute that is directly linked to the constitutionality, they are governed by laws rather than the constitution. Just an example, one administrative court's local court was to decide on the status of the judge of the Constitutional Court, and the status is determined by the law on the Constitutional Court, but the decision was based on the rules of procedure of the Constitutional Court and ignored the provisions of the Constitution and provisions of the law. So the rules of procedure of the Constitutional Court prevailed as the ground in this decision, and the Grand Chamber found the letter, even the one that is missing the features of the regulation. I mean, the Grand Chamber of the Supreme Court. And in one of the decisions, the Grand Chamber of the Supreme Court said that the Constitutional Court is a political body in a way. So, well, basically, to some extent, it could be the truth. When it comes to delineation of the competences in a place in jurisdiction, so that's the mechanism when the administrative court stops proceedings until the constitutionality of the legal act is decided. So we had the situation when administrative courts applied the law on cleansing of the power. This law has been pending with the Constitutional Court for 10 years. By the way, this court was adopted for a shorter period of time. Due to specificities of the law and specificity of the composition of the Constitutional Court, the Constitutional Court cannot decide on its constitutionality, and therefore administrative courts have to address this issue on their own, since the Constitutional Court was not able to decide on this issue. The law, has lots of different elements, affiliation with the parties, corruption elements, and everything, and the composition of the court. And these are the elements that made this failure. If it is one or two votes that were missing, the decision would have been taken, but that was not the case. Potentially, a similar situation was seen when we examined some political orders regarding suspension of the judge of the Constitutional Court and the powers of Kosminin and Tupitsky, judges of the Constitutional Court. So along with this case, there was a case to the Supreme Court that was submitted. So it was the Constitutional Court that was to decide first, because the question was relevant to them, and it is the Constitution that determines the powers, and the president is not entitled to dismiss the judges of the Constitutional Court. But the Constitutional Court happened to be kind of, on its own in its situation, but they were to decide on that, and the issue could have been addressed, but it didn't happen. Why? Because, again, what was missing then? They didn't have sufficient courage. And as Mykola Natovsky said, the Constitutional Court should be respected. And it is the judges of the Constitutional Court that should respect the Constitutional Court. Then everybody will have this respect too. I am too conclude to discuss the issue whether the plenary session replaces the Constitutional Court or acts as additional filter when it comes to preliminary control. It could be both or either or, but it depends on the submission of on the nature of the question that is submitted to the Supreme Court. The submission to the Supreme Court should be well grounded with clear arguments that show that the legal act in question is contrary to the Constitution. Therefore, the court or the judge applied the Constitution and its direct effect. The plenary session is entitled to decide this issue, deciding the issue as to the submission regarding constitutionality of the legal act to the Constitutional Court. The plenary session should not automatically accept all submissions to the Supreme Court. On the other hand, it should act properly to decide that, and the correctness of addressing a particular issue will define how the plenary session is going to act as a filter in submissions to the Constitutional Court, or will perform the function of the constitutional review if the plenary examines the submission as to admissibility, whether there is an issue of constitutionality is there, then it acts as a filter to sift off the ungrounded submissions. Usually, plenary session looks at the reasons that you see in the submission. So the plenary session says, okay, so the submission was not properly grounded, that's why it's not accepted. And the lawfulness of this dismissal is apparent, especially if administrative courts raised irrelevant issues just due to changes in legislation. So let's say new laws were adopted. The plenary session is governed by its resolution of 2025. The plenary session refuses the courts to go to the Constitutional Court if there is a position of the Constitutional Court that was expressed in a specific case, and it covers this issue. That's the resolution of 25 February, and it clearly is said that the Supreme Court addressed this issue and it shouldn't go to the Constitutional Court. If the plenary session decides that the issue on the merits that is raised here, then the plenary session exercises constitutional review, this way taking over this question from the Constitutional Court. That's exactly what was done by the plenary session when the submission to the Constitutional Court was dismissed, because it was about the pensions and it was in line with Articles 116, 117 of the Constitutional Resolution of May 2025. I believe so, because in its reasoning, the plenary session said that this procedure is in line with that and that. That's why they didn't want to refer this question to the Constitutional Court. Generally, when the plenary session, upon the request of the court, decides on the constitutionality of the acts or laws, seems to be justified, provided that when decided on this, the plenary session is not going to replace the Constitutional Court, especially given the fact that the plenary session decisions are not final regarding constitutionality of legal acts. So if the plenary session refuses to accept the request from a specific court, this issue could be raised again and conclude. Today we heard about constitutional petition, constitutional complaint about the right of the Constitutional Court, or rather the right to the Supreme Court to go to the Constitutional Court, and the colleague from Croatia said that every court could go directly to the Constitutional Court. The colleague from Lithuania spoke about a constitutional petition in Ukraine and said that every person could go directly to the Constitutional Court. So in 2025, the plenary session of the Supreme Court had 9 requests from the courts and dismissed 6 out of 9. And during that time, more than 400 constitutional petitions were submitted to the Constitutional Court. Half of them were dismissed. That's a secretariat that is entitled to do that because they look at the formal requirements to be met. And if not, it could be returned to remedy that, but half of them have been referred to the judges to be considered. So 9 requests from the court and 400 petitions to the Constitutional Court that were submitted directly. It doesn't make sense to give this right to the court. It seems to me that a judge and a court are more qualified and can do it better and submit well-reasoned submissions. I don't see any risks here. Maybe I don't understand the administrative process very well and potential risks. Thank you. That's what I wanted to say. Thank you for your analysis and for your presentation. It doesn't feel that you are a retired judge of the Constitutional Court. You said you had questions. I have a question to Virgilius. Are you with us? Yes.
Суди звертаються до Європейського суду справедливості.
Go to European Court of Justice regarding interpretation of the Charter, directives, etc.
Отримують відповідні висновки.
And receive respective opinions. I take that, and you quoted examples that European Court of Justice recognizes European acts as prevailing over the constitutions of the member states of the EU. So if Constitutional Court submit requests regarding constitutionality, do they take into account EU legislation, or they are more focused on their level? And
в одному з рішень проти Румунії, що
as we see from Romanian decision, where European Court said just ignore the decision of the Supreme Court. What should the Constitutional Court do? Because in our case, Constitutional Court could use anything they consider appropriate. In the instance of the member states, maybe they should apply legislation of the EU rather than national legislation to address the issue they are facing. Thank you. Thank you for your question. We have to start by saying that Court of Justice cooperates with constitutional courts of EU member states, and in most of the cases, they find through informal meetings, through formal meetings, when Constitutional Court delegations come to the court in Luxembourg, the head of the delegations, the presidents of the courts meet with the president of the Court of Justice. So there is a dialogue there, but When you talk about prevalence of the law or EU legislation, then it is clearly stipulated in the treaties. And if a member state submits the request to the EU court, then the government, the parliament, everybody is aware that if there is a conflict, then EU law will be a bit higher. I'm not going to give any specific examples to illustrate that. A very serious constitutional court of the EU, and starting last century, in 1970, in 1986, Solange 1 and 2, there were two cases there, and then in 2021, on 20th of May, there was a decision made in the Constitutional Court of Germany that recognized that Court of Justice decision is not in line with the Constitution of Germany, and they had a specific case in mind. But later they found a political solution to that, and that was basically it.
These cases are very unfrequent where the Court of Justice has to say that directly, but these are the realities. I know that when I communicate with functionalists, starting with the Maloney case, the constitutionalists of the EU member states were very unhappy with the decision of the Court of Justice, but that's the reality. That's how it is. Thank you. Thank you. Thank you so much. And another question to you as an experienced person. You were a judge in Lithuania. You were the president of the High Administrative Court of Lithuania and judge of the European Court of Justice, and you have significant experience in our practice of European countries and not only. So let me share that I don't really like this situation, even though being a judge of the Supreme Court, I have to defend the plan, but I don't like that situation because I see that there are significant mistakes, errors made in motions to the Constitutional Court. So do you think that it would make sense if courts could do that directly in Ukraine? Look, in Ukraine, I believe there are 8,000 positions of judges, and currently up to 5,000 of those are filled in. At the level of the EU, we have about 80,000 of judges, and all of them have the right or the duty to go to the Court of Justice. And just as Mykola said, in constitutional courts of member states, there are the teams, the officers that apply internal filters. There are lots of cases where that's not in line with formal conditions and requirements, and they do not go further then. However, I also have this idea that if with an individual complaint, any individual can go to the Constitutional Court and the court accepts that. I don't see the logic. I don't see the reason why we need to limit professional lawyers and I mean judges in course of any instance. And they are going to the Constitutional Court directly without filters. So I believe that if there is more practice of the Constitutional Court, the more than protection of human rights. And I absolutely agree that the Constitution of Ukraine, as well as most other constitutions, they are great documents, but that's on paper, right? But with the practice of the Constitutional Court, we can provide for the rights at the national level. Thank you. And then I also have this question. In order to allow that to courts, I mean, should they wait for the decision of the Constitutional Court, or then they should address the Constitutional Court? Well, I understand what you mean, and that's a very so we don't know how to go around that, because I remember that in 1990s we had these discussions. So that if us judges of any jurisdiction, if we can directly apply articles of the Constitution, and then after many discussions, we arrived at the conclusion that it's better to do that via the Constitutional Court. Today, somebody said that this is the French doctrine, that this is the acte éclairé, and this doctrine was also undertaken by the Court of Justice in Luxembourg. So it is possible that there is clear practice of the Constitutional Court, and the legal provisions are very clear. So in order not to waste time, I believe that a court of any jurisdiction where everything is clear may not apply the law in a specific case, but I believe that courts of general jurisdiction or administrative courts, so I believe that so whether they can express that, whether they are in line with the Constitution or not. Well, you know, the issue is that the plenum of the administrative court rejects that, and well, judges, they just resolve the case as it is, and then the decision is made that the law is not in line with it. So this rejection by the plenum does not matter for the practice of court. So thank you very much. Any other questions? Because time is over. Almost any other questions? If not, then I believe that we can proceed with summarizing. Mikhail Ivanovich.
Дорогі друзі, завершується наш захід.
Dear friends, we are ending our event, and frankly speaking,
і висновки на заході такі,
our findings
які, я вважаю, мають бути всюди. Ніяких імперативів, тобто ніяких вказівок. Це все для ваших міркувань, все для ваших думок і для обговорень, а також для застосування під час вирішення конфліктів. І, звісно, ви чули всі ті проблеми, які є, їх розв'язати дуже непросто. І чули цю взаємодію конституційного та адміністративного судочинства у забезпеченні верховенства Конституції України.
various links between the administrative and constitutional justice. So I believe that this seminar is another important step towards understanding the role of Constitutional Court and administrative justice in implementation of the rule of law. Everywhere in all the countries that I have visited, everywhere we see some contradictions, and you see now in EU countries, even decisions of the Constitutional Court can be ignored because in the EU directives there may be some other interpretation. So everyone, of course, fights for or promotes interests of their institutions. So I work in the Supreme Court, so I couldn't say that only the plenum does that, like the Grand Chamber. But that's not right, because we can expect there some misinterpretations. We can see that
якщо всі суди звернулися, а пленум не звертається, тобто закуркував оцей вихід суддів до Конституційного суду, так бути не може. Так бути не може. Тим більше за цим всім криється конституційна скарга і так далі. Звісно, ми повинні все робити, щоб суддя був почутий, щоб суддя був почутий.
And we are supposed to do everything so that the judge were heard. So I have been working in the independent Ukraine.
Міг навіть звернутися до Пленуму Верховного суду України. І такі були випадки, що Пленум
go
Верховного
to the
суду
plenum
України
of the Supreme Court of Ukraine,
скасував рішення всіх
and
судів,
there were cases where
суду без змін.
all the decisions of all courts were withdrawn, cancelled, and only Ludsky court, their decision was
і так далі. Чому так воно все в нас зроблено, що як куркується пленумом, на мій погляд, це неправильно, це треба врегульовувати.
Of course, I believe that this is an aspect that needs to be regulated. At this event with Miroslava, with other colleagues from the Secretariat, we try to invite the best experts. I believe that we have succeeded. We have developed contact with Mykola Ivanovich. And of course, we could hear about diverse ideas and opinions. Of course, our colleagues reflect and express their vision, and we can use. Again, regarding the plenum of the Supreme Court as the preliminary control instrument, if we only dissipate that for the plenum, their decision must be relevant for courts, and if it doesn't happen, that's
в минулому році пленум відмовив, суди як вирішували справи, так і вирішують, вважаючи норми закону неконституційними.
That withdrew, but the courts proceed with their practice, and only this year, courts of the Supreme Court, they started thinking about their rights as well, and then the decision was made to submit the constitutional motion to the Constitutional Court.
Ми повинні, і це ж
So we do need to, and that's not judges who need that, because judges, they protect the rights and interests, freedoms of individuals. So if that decision is made by the first instance
Заборонити його думки,
court
щоб
judge
переглянули у стадії,
prohibiting
конституційній стадії, з Конституційного суду, на мій погляд,
review
такого
of this
бути
standpoint
не
in
може.
the Constitutional
З
Court,
практик
the
скажу
system
вам
seemed that
так,
was not
що де я не був у
based on my
судах
practice.
адміністративних, і
I've
найбільший такий приклад – це
worked in various administrative
адміністративний трибунал
cases.
міста Страсбурга.
In particular,
Скільки
we
справ було? 7
visited
тисяч.
Administrative
Скільки було
Tribunal of
проваджень
Strasbourg.
судів?
There were
2. А де 5
7,000
тисяч? Є
cases,
секретаріат,
and
який на тій
2
стадії
were
вирішив усі
under
ці питання.
consideration
Такий
of
секретаріат може
the
бути і в
judge, and the rest was addressed by the
Конституційному суді.
Secretariat.
Тому,
So this kind of
звісно,
secretariat
над
could
цим
also
ми маємо
operate,
працювати,
work in the
доносити це
Constitutional
нашим
Court. So this is something that we
депутатам,
need to work on.
законодавцям.
We need to
А
convey
так,
that
я
to the
вам всім
legislator,
дякую, що ви
this
були
possible
на
approach.
цьому
So
заході, що
thank you
приймали
for having
участь в
visited
цьому
this event.
заході.
Thank you
І
for
я
participating.
переконаний, що він стане вам
And
дуже
I'm sure
помічним.
that it's going to be
І
very
такий
helpful in
приклад,
your further
такі
work.
приклади навів і Микола Іванович, і
Микола
Гнатовський,
Іванович,
по-моєму, за це говорив,
Mr.
що ще ми
Gnatovsky
маємо бути
mentioned
сильні
several
духом.
examples that prove that we need to be resilient and
Звісно,
strong.
нам найтяжче.
Right?
Суддям
Because, of
адміністративних
course,
судів
this is
найтяжче,
hard for
тому
us,
що ми в
it's hard
політиці,
for judges of
ми в
administrative
політичних
courts
відносинах,
because we are
що
in
тиск з
politics, we
усіх,
have this
з
political
усіх боків.
relations,
Але
and there
мені
is a lot
приємно
of
чути,
pressure.
що
But it's nice to hear
лежать справи в Конституційному суді
that
України,
there are cases in
а
the Constitutional
адміністративними судами
Court
вони
of
вже
Ukraine,
давно
while
вирішені. Це по
administrative
суддях
courts have
Конституційного
long
суду.
addressed those.
Мені приємно чути, що
So it's nice to
закон
hear
влади лежить
that
в
the
Конституційному
law
суді України 11 років, а вже всі давним-давно справи
on
вирішені
illustration
в
has been
адміністративних
there
судах. Вже
for
немає
11
необхідності
years, but in
перевіряти, чи він там
administrative cases,
відповідає
all of those
Конституції,
cases have been addressed
чи не
already. So it
відповідає.
makes
Але
no
мені
sense to
неприємно за Конституційний суд.
inspect,
Неприємно.
to check the
Тому
constitutionality.
я
But
ще
of
бажаю, щоб
course,
ви всі
this
були
is
сильні
not
духом. Так,
nice.
я
So
ділюсь вам, що з практики буває,
I
що
wish us
ніхто не
all to be
задоволений рішенням.
strong
Але
in
основне, щоб ви
spirit,
були
because it
задоволені.
happens that
І
people are not
Бог бачить,
satisfied
що ви
with the
винесли
decision,
справедливе
but
рішення. І
it's important that you feel
така наша
that
доля,
your
якщо ми
judgment
хочемо
is
бути
fair.
суддями.
God
Тому я
sees
вам
you, and
бажаю
that's
всім міцного
our
здоров'я,
destiny. If
успіхів у вашій нелегкій
we want to be
роботі,
judges. So I wish
родинних
you
таких
health,
вам
every
затишку,
success,
тепла, світла і
happiness in your
бистрішої нам
family,
перемоги. Ми
families,
все
and
зробимо, щоб наша
looking
Україна
forward
процвітала.
to the Ukraine
І
to
нам є чим
prevail.
ділитися,
And we'll
бо
do
ми
our
маємо
best. We
їздити,
have something
збирати
to share.
практику по Європі.
And of
Уже нам
course,
є
we
чим
can learn
ділитися. Вони
from
мають
best
приїжджати до
practice, best
нас і
European
брати
practices,
наші
but we
практики,
also have something to
нашу
share.
таку
They
працездатність,
should also come to us and learn from
працелюбність,
our experience,
такі жертви своїм вільним часом. І вони просто
where we
дивуються,
are
як такі
ready to
навантаження ми маємо,
sacrifice
і
our
справляємося з ними, і
time, and
відстоюємо права
sometimes our
людей, і
colleagues are
гарантуємо
surprised with how we manage
священний
to
наш обов'язок і гарантувати право на судовий захист
work
громадян України,
efficiently and
людини,
guarantee
приватної
the
особи
right for
в Україні. Тому що
the
воно навіть не може бути
judicial
ущемлене під час
for
війни, під
administration
час
of justice,
військового
because this
стану.
is the right
Дуже
that
вам
must
дякую.
not be undermined
Дякую,
even
Михайло
in
Іванович.
the
Ну
war.
і залишились такі
you.
загальні, як сказав Михайло Іванович, ми не можемо ніяких рекомендацій нікому один одному робити. Та ми
As mentioned, we
поважаємо
cannot
один
come up
одного.
with
І
any recommendations.
і в зв'язку з цим я дозволю
In
Михайлу
this
Івановичу буквально
context,
пару речень, ми вже завершимо,
let
будь
me
ласка.
say just a couple of words.
Що важливо, та неодноразово було підкреслено сьогодні,
What's
що
important,
конституційні
as
і
we
адміністративні суди, вони
emphasized,
повинні крокувати
constitutional
разом.
and administrative
Все ж
must
таки всі
stop
погодились, що нам потрібно
and
встановлювати
develop
постійні,
together.
стабільні
Everybody
інституційні
agreed
зв'язки
that
між
we need
Конституційним судом і судовою системою.
To set the links between the administrative court and the judicial system, and it's obvious that our colleagues are elected for the Constitutional Court, and also it is obvious that we need this ongoing dialogue with various jurisdictions that must happen beyond the formalized channels. For example, it makes sense to organize this kind of meetings and seminars as we have today. And finally, I would like to express gratitude to everyone who has contributed. On my behalf, on behalf of my team, I would like to express gratitude to those who have supported this event. This is Lina Huber, Natalia Avanyuk, and the listed colleagues. And of course, I'm grateful to all the providers, the interpreters who worked with us today. And also, I'm grateful to our colleagues, our judicial champion led by Zhanna. They supported us in all initiatives and they help us move forward, progress, and to prevent problems. So thank you all. We are grateful to our experts, to the students who have come to us. Thank you, Mikhailo, for your supporting the doctrinal approach, the conceptual content of our legal positions and their implementation to ensure unity of practice, to protect human rights. So thank you for your patience, for your time, and for the discussing the important issues that we raised today thanks to international actors. Thank you so much. So we end for today and we look forward to further meetings, and our event is over.
Дякую вам. Всього найкращого.
Дякуємо всім. Погоджуюсь, дуже гарний семінар практикум і до наступних зустрічей.
Так.
Thanks a lot, colleagues.